reopening, if I'm on the criminal, I mean, you can have a plan for the orders. Anyway, I have something in mind,
Gotcha.
work it out.
Gotcha.
Okay. In the second half, we'll try to accommodate it.
Yeah. Okay.
This motion be item number 1.
Yes.
Yeah, please, Your Honor.
Oh,
Yes, this is the regular bail application, my lord.
yes, yes, yes.
The petitioner, my lord, earlier your lordship has rejected the
It's okay, no problem.
bail application. Now, on conclusion of the 22nd days, now he is now 32 days in the custody. 60 days is the maximum period, my lord.
Okay.
My lord, this is a case, my lord. Basically 7 years, my lord. I'm not on the factual metrics on this case, my lord.
At the moment.
Because already at this stage, as lordship has already opined, my lord, in the last rejection order, the maximum punishment here, my lord, is 5 years, my lord.
Mhm.
It is under section 132 of the 132 1BC
Right,
of the Goods and Services Taxes
right.
Rule, my lord, GST
Mhm.
Act, my lord. Now, my lord, my only contention at this stage before your lordship, that is in violation of the mandatory provision, this petitioner was arrested, my lord. My lordship kindly see he was arrested on 14/11/2025, my lord, admittedly, my lord.
Page number
Page 22, my lord.
22.
Arrest
Procedural
memo.
information.
Yes. Page, my lord, 22, that is the arrest memo, my lord.
Hmm. Hmm. Right.
14/11, my lord, he was arrested. Now,
Notebook. date?
notice also been served, my lord, on 14/11.
Yes,
47, 48, these are the, that has been complied with, my lord.
I see.
Now, lordship kindly see, this is a, now, the regarding our only contention, the notice under 35(3),
Mhm.
which is not been served
Mhm.
as required, my lord.
Or grounds has to be given, right?
Lordship kindly see the, there are two things, my lord. Lordship kindly see that is notice is page 41. Very interesting aspect is there.
Yes, show me.
41. The dates are very important.
Page number.
Page number 41, my lord.
You want?
Right copy is 41, my lord. Now, this notice, as per the law, it has to be served prior to the arrest, my lord.
Yes, yes.
Necessarily, my lord, this is notice needs to be served to me on the prior to the arrest. Now, kindly see the content of this notice, my lord. To Bahadur, in exercise of the power conferred under section 3 of the 35 of the BNSS, I hereby inform you that during the investigation of the FIR of the case, so and so, so and so, so and so, registered and so, it revealed that there are reasonable grounds to question you to ascertain the facts and circumstances from you in relation to the present investigation. This is on investigation, my lord.
Mhm.
Hence, you are directed to appear before me on 13/11. The notice was served to me on 14. Signature, lordship, kindly see. When I received it also 14 and the signature of the IO is also 14.
When was he arrested? On
14 itself.
14th. I don't know. Appears to be a. Is it a typographical?
No, my lord. The original I have. Original is the
No,
next.
there
page.
also they have made the mistake. No, they must
Original-
have made a. How can it be? Obviously, it cannot be on 13th. Right? It has to be on 14th or 15th. It cannot be on 13th.
Cannot be on 13 and 14
That
also.
is
Had it
obviously
been,
a typographical error. 14th also will be slightly.
if it is 14 also,
Also,
my
it will
lord,
be too fast.
the date of arrest, you are serving me the notice to appear. It can't be.
One day has been anyway. So that's true.
So this is an absolute violation. Appears to be. You pick me up and suddenly, so that what actually happened, my lord, this notice has been actually inserted subsequently.
No, that you, they'll
That
answer
is
those
my
questions.
position, my lord,
Fine,
because
fair enough.
when I have been picked up, you have not served the notice. So to bypass the requirement of the 35, subsequently you have served the notice.
So 35 notice, if it is not given, then it has grounds has to be given. And if it is given, then
Yes, yes.
and
and
despite
why I am saying so, in
despite the notice, if he appears, he cannot be arrested unless
yes,
you give the
give a
reasons.
reason.
Of
And
course,
Your Lordship kindly see,
two
in the complaint petition which has been filed, that is in page 27,
Mhm.
there is no indication that they have served the notice on 14.
So 35 notice is bilingual also. Anyway, we'll
Yes,
see.
bilingual also, here also, it's a bilingual notice.
Mm.
The original Lordship will find at 43, that's a bilingual notice.
Hmm.
And why I am
Appear
saying
before
so,
me on 13th. Yes, no, no, here also in the original one, it is written as 13.
yes, yes,
1311.
yes, yes. That
So
is
he-
original also,
there-
it's a bilingual.
13, it has to be 13. It has
It can be on 13, you have,
How come it is, he signed as 14.
yes, he signed on 14, I have been served on 14. And you have asked me to appear on 13. And in the complaint petition, there is no mention why I am saying so, that the Y35 was not served in me, because in the complaint petition, there is no indication about that it has been served on me.
This is obviously their mistake on their part in writing, but the thing is that it was issued on 14th because
That mistake, Lordship cannot take the presumption that this is a mistake bona fide unless and until they have
Yeah,
filed it.
because obviously a person cannot appear yesterday.
Yes.
It has to be either
So-
at least earliest is today.
My lord, on that day also, what is the purpose of my lord, the 35?
Mhm.
Let us take it, my lord, that the date has been served on 14 itself.
Mhm.
In that case also,
Same day also is slightly
Yes.
unfair.
suppose, same day also.
At least
you are
one day has
asking-
to be given,
In
maybe.
the investigation, you are on investigation, asking a man to appear on that day itself, you will arrest. And when you will arrest, you have to comply with all the mandatory.
No, on the
provisions
day
of-
of appearance, he can be arrested, but
Yes,
if I'm
he
not
can be
wrong.
arrested, my lord.
But
There
the
has to be sufficient
time
for
for
that.
appearance, some time has to be given.
And no, my lord, then the reasons has to be that yes, we served the notice, but during investigation.
No, that's okay. But for suppose I'm given the notice, at least maybe one day should be given.
Yes, my lord.
Unless
now-
there is something very
the-
urgent.
In the 47, 48, now the Supreme Court has come up with the judgment that at least 2 hours. 2 hours is the mandatory period.
In the grounds.
In the 47, 48 notices,
Yes.
2 hours before the production.
Yes.
Even in the 35,
How will he prepare otherwise?
yes, how will he prepare? And in this case, I have been asked to appear. Probably I have to now travel in the past, my lord.
No, that's obviously wrong. Anyway,
So when I have been produced, suppose, then Lordship will find why I am saying so. There is one more notices. Lordship will find page 21. What they did when they saw it that it has not been complied with, it was subsequently served. Then they have served me 21, page 21 summon. In that case, they have inserted a new thing, my lord, that this is a notice under 35. It can't be a notice under 35 anyway. Page 21, my lord. It's just below the summons, my lord, under section 70, Central Goods Self-Service Summons. So read with section 35 of the BNSS Act. How it can be a summon, that is a notice, and that notice is during investigation, my lord. 35 notice is always during the investigation, and this summon under the section 70 of the Central Goods is during the inquiry. Both cannot go together. And the section 70.
inquiry and investigation are they
Both
have
are
to, they are
different.
separate.
Separate, my lord.
No. We know in CRPC context is separate, but there is a scope for a preliminary inquiry in GST matters. Scope for. Anyway, we'll come to that.
Yes. And
We'll
the
answer.
Lordship kindly, this 70 is governed by the CPC, not by the CRPC, madam.
I see. Oh.
Lordship will see
I
that the
see.
Central Good, the section 70 is very fast. GST Act is.
No, we have the GST Act. For 43, page 43 is the notice, right? This 35-3 notice, which is or the discrepancies with regard to the date. Otherwise, the contents are bilingual. Anyway, we'll come to that later. We'll come to that later.
Date itself, let us
Okay.
Assuming
Uh.
that it has been served on 14 itself. Then what is the purpose of that 35 notice? And you have to indicate in the order. Now I'll come to that.
Can we look for any judgment guidance?
Yes, yes.
Of that,
Yes.
how much time should be given for
No,
the
no, that
35
is
notice?
35, I think there's
I've
no
not
judgment.
found. I've not
In
found.
now it is
No,
come
no, we
according-
can always miss. There are so many judgments now.
No, no, on
But I have not found.
Yes.
But this 2 hour thing has come.
2 hours thing. has
Something like that is not there, bro.
come. Not there. Till now,
So
not there.
it has to be taken as reasonable.
Reasonable, yes, reasonable time. So that I can prepare myself. And you'll go to an investigating authority. Suppose I have been asked to produce some documents in GST case related. How I'll prepare all those documents, my lord? These are all documentary matters, my lord. That whether your GST number, everything is related.
At this stage, shall we call for the updated case diary?
My lord, probably my lord, I already
Friday, lots of.
co-accused is fixed today. Probably that case, the case there is there.
That's it, they have not sent the case diary.
And
Because-
kindly, since the Learned Senior Council has made these contentions, as you know, so as the standing council of this, revenue, representing revenue, kindly, you must have taken note, these things, so where the time and whether these two things that it cannot be his one contention is summons come 35 notice, it cannot be. Secondly, the age discrepancy, the date discrepancy, and on say it has to be taken as 14th only. Obviously, it cannot be 13th.
Is the Honorable Court granted bail on this ground? The department has filed SLP that in case of GST 35 compliance is not necessary. Because it is a special act that is under consideration, right? And
Under
it-
consideration, how can it be a submission, my lord?
And back in.
Larger
condition-
bench,
But yes,
larger
but-
bench.
No, no,
no,
larger,
it's
larger
Supreme
than
Court.
Supreme
SLP
Court.
has been filed.
But there is no stay order. Is there any stay order to that effect?
Lordship, may I please
No, when there is no stay order, there is no question of
Let-
making
let
the
me-
submission as well.
Let me submit, Lordship. I'm just informing your Lordship
That's a different
that
issue.
SLP has been filed and Supreme Court has issued notice in this case.
No,
Is there any stay order of the
no,
order
no,
of the House?
I don't think you need to argue also that the 35 notice is not there, but the date is, see, the only problem with your 35 3 notice is an elaborate notice in 2 languages, right? The only infirmity Learned Senior Council has pointed out is that the date discrepancy and whether, it is reasonable in a case like this. Since there is no, so far you have not noticed any case law about stipulating time, we have to constitute reasonable time, whether in a case, whether it gives such an unreasonably short time that it amounts to no notice, that kind of thing. That is what I have understood by submission.
Yes.
So you kindly take it and you try it Thursday, Friday, last day.
Thursday.
Thursday I'm going to Itanagar, Lordship. Maybe it's on Friday.
Friday. Okay, I can fix it.
Tomorrow also then they can take up, my lord. There is one case is already pending.
Here,
Number 19.
This court.
I think it's same today. And in that case, my lord, the case that was called for earlier.
Achha.
This is a motion stage.
Lordship, it's on Friday, Lordship. I'll complete the query raised by my learned senior.
Let you work it out, both of you. Whatever is convenient. Learned Senior Council, AM Bird, who fairly submits that an earlier bail petition was rejected by this court on high level. And they did with the past in so and so. Full stop. The new grounds adduced by the Learned Senior Council is that there are infirmities in the notice under 35(3) to the extent that his arrest might have been vitiated. Full stop. Also heard, SC Learned Council, call for the updated case diary list on Friday. Okay, we'll see it. But this is a new thing, 60 summon, 70 summon, it's under CPC. No, I was, yeah, I was.
70 of
Yes,
GST.
yes. As you know, you only, Mr. Kyle, sir, he only, helped me to learn this and the earlier, some other matters, that Radhika Agarwal judgment has clearly said that the principle, all these procedural things of CPC will be. No, I did not know. He helped me learn.
Yes, Lordship.
Hmm.
Provision of CRPC.
I had heard about the judgment, but I had not gone into it.
Yes, applicable in case of GST.
Yes.
This was not there.
Yeah,
but
because
since Radhika Agrawal-
any arrest is arrest, right?
Correct.
So all these things, it's
Rest is same, CRPC will be followed, madam. But this is, the act is still
We'll see.
stipulated, madam,
We'll
that
see.
is CRPC.
we'll see.
CPC, madam.
We'll see.
I'm ready to 70.
CRPC.
CPC, Code of Civil Procedure.
And that we'll,
Civil-
we'll see it,
Seven
check
to
it.
seven.
We'll learn it. Okay. Some,
It is judicial procedure, notice procedure.
we'll see it. You are clear? Report was called for.
Yes.
Report Lordship.
Or report was received also, right?
Yes,
Yes,
Lord.
Lordship.
Further instruction was sought whether any complaint or GDA.
Oh, I see, I see. Uh-huh.
Complaint and re-entry against the petition Lordship.
No complaint in GD entry. Complaint was filed, but it has not been made into a GD entry.
Yes.
So at this stage, no need. Sir. If it's registered, you can always come again,
Yes.
right? It is submitted by Mr. D.P. Goswami, learned additional PP, upon instructions from the, which police station? This one is Lonka PA station that there is no FIR registered or GD entry made with regard to any complaint filed against the petition. In view of the same, at the moment, there would be no basis for apprehension of arrest, and accordingly, this petition is disposed of as not mandated. I need not say anything else. You can always come again.
Yes, Lord.
This on this poster.
Bail hearing BA item number 10.
PP?
Case diary was called for. Lord.
We have received the case diary, but the statement of the petitioner is not in the case diary.
They have appeared, Lordship.
AB is before today. Failure, Huh? Huh? Oh, no, it's AB only, but this is an AB. This is an AB, others are B. No, I see it wrong. Okay. So,
Petitioner is an interim Lordship.
They have appeared, Lord.
They have appeared, but statement,
yeah, but the only reason they were given an interim is that they are not named in the FIR, right? But so, a case diary has been received.
yes, okay.
What are the materials with regard to them, if any? Case diary is not updated. It's-
Not updated, but because updation, last updation is 8/9/25.
8/9,
26/9/25.
they're long back. This is
Long back.
interim was considered on
Yes.
8/12.
Interim was
Last week.
It has to be sent back.
8/12.
But otherwise, there are no materials, so we have to update it. Anyway, the petitioners were granted interim pre-arrest bail on 8/12/2025. Full stop. And the learned counsel submits that, Ms. Yashmin submits that as per her instruction, they have appeared. And statements recorded also, statements also recorded, full stop. However, the case diary though received is updated only till
26/9.
26/9/2025. The case diary may be returned back and procured again with the updated investigation, including the statements of the petitioners. So the interim bail stands extended till the next date. You can suggest a date,
8/1/26.
8/1/2026.
Much obliged.
Only say it or ulai jabo boslo.
Item number 11.
This case, Lordship, trial court's record was called for Lordship last occasion. He is in jail. completed nearly once 179 days, that is 5 months, 26 days. Lordship. And trial is on, Lordship, perhaps three witnesses were examined, Lordship. I have annexed one evidence for the informant, Lordship. But she has stated, Lordship, in her cross, Lordship, that page 29, Lordship.
Just a minute, sir.
Lordship.
Attempt to murder. Huh?
That there is some dispute of land lordship regarding that, and it's a purely a lordship. And he will face the consequences, lordship, whatever the trial lordship. I pray at this stage, lordship, is to arrange for his trial lordship. He is the only earning member in his family, lordship.
Mr. Borua, submissions?
Yes, madam. Madam, scan copy of the record, madam, the evidence of PW1 is not available, madam.
I have annexed the same lordship. In my certified copy, I have annexed.
Otherwise, madam, he sustained grievous injury, my lord. And accordingly, my lord, search was framed, my lord, under section 1182, my lord.
Which is attempt to murder.
And 109 is attempt to murder, my lord.
Trial, I
Previous certain attempt
Yes.
to murder.
So as far as the materials are concerned, my lord, as on that, my lord, there are materials, my lord.
Let him face the trial, I think.
he should face the trial lordship. I pray lordship.
Since June, he is in custody, so let him face the trial. Heard, Mr. K. Mozumdar. And you are appearing for the informant. Sorry, I have to hear you also.
Convicted under
Maybe
section
convicted.
302, murder case.
Earlier convict, he's in jail.
Already convicted,
No, lordship.
He's in jail.
not now, not jail, less earlier.
He is in jail now, lordship. 17. And
Jail.
302, so he will be,
no, lordship, it was a 307, lordship, that earlier conviction will not affect the present case,
no,
lordship.
that's.
I pray,
That
lordship.
may not, the earlier conviction,
Antecedent.
he's
criminal
on bail.
Yes.
After conviction, he's on bail.
No, after conviction, he was.
Lordship may kindly come to page
Bail.
number 16 of the bail application, my lord.
Page number 16.
My lord.
Nowadays, there is also a direction. You must have informed, because the earlier criminal antecedents have to be informed. There's a judgment, no, recently.
Lordship.
Not very recent, actually. It's some, I think, 2 months back or something, 1 month back.
Page number
1.5
16,
months back.
Ramdo Perez. Clause number B.
The criminal antecedents have to be disclosed. It's not that the court will be, taken influenced by, only
Lordship.
influenced by that, but they have to be disclosed. That is the page number
Page number 16, my lord.
6. I'm on 16 only.
Ramdo Perez, my lord, clause number B, my lord.
Convicted for 7 years in Murajar case. 302.
That was reduced lordship. But my
No, it
resolution.
cannot be 302 because it's some other section.
Lordship.
302 years.
No, 302 would be life
304, it
imprisonment.
was 304 lordship.
30, 7 years cannot be life.
Lordship.
Obviously, it's a typing here. 302, you have only two choices.
See, I have the online copy, print out from the site.
So you are opposing to the
Will
bill,
not be
obviously.
open. Inform.
I resolution some
Case number
criminal,
and sections.
criminal antecedent may not
Then also
be a ground to deny his bail lordship in the instant case. He is to face the trial lordship. Trial is on lordship, and he will cooperate with the trial lordship.
Okay. So that is what I'm asking. It's okay. I can look at this independently also. But the thing is, I'm asking that in this case where he was convicted, he must be on bail, isn't it? Otherwise, granting bail in this will not help him. He will still be in custody.
Lordship, he was in bail.
He's got bail in that appeal.
Lordship.
He's filed appeal. He must have filed appeal, right?
I think.
He must have filed appeal.
I don't.
Anyway,
File appeal on.
I'll confine to this,
Lordship.
to this matter only.
And
My lord, there is a chance of my lord hampering and tampering with the witness.
now, lordship, with all fairness, I am submitting. He will cooperate with the court, honorable court, lordship. Already matter is subject before the court. And the earlier antecedent may not be denied.
Cases of similar type is not a good thing. But
Certificate,
anyway.
your lordship, status is this judicial custody, your lordship, this is custody, your lordship.
Heard came on that so and so. And RJ Boda for additional paper. Mr. Karim, right?
Let's,
Yeah,
yeah,
Karim and Council for Informant. Likha hai. Full stop. Invoking 483, the petitioner here in Nazrul Haq is seeking regular bail in connection with Murachar PS case number 108 of 25, which after investigation resulted in a charge sheet followed by framing of charge and presently stated to be at the stage of trial. The petitioner has been accused of causing previous hurt and attempt to murder. He was arrested on
Arrested on
28th June, 2025, and presently in judicial custody. Full stop. In the trial, so far, one witness have been examined.
lordship, as per my instruction. Three lordship.
3 witnesses have been examined as submitted by the learned petitioner counsel, whatever it is. The learned counsel seeks bail contending that the petitioner will cooperate with the trial. The learned additional PP, on the basis of the scan record received, submits that there are incriminating materials against the petitioner, and if granted bail, he may,
PW1 examined, my lord.
he
He
may,
is implicated.
uh, and he may influence witnesses. Full stop. Mr. Karim, the learned counsel for the informant, also supports the contention of the petitioner. Full stop. I've given my anxious consideration to the issue. Full stop. In the charge sheet, how many witnesses are full stop? It is also pointed out by the prosecution and the learned counsel for informant that the petitioner was convicted and sentenced to 7 years in another criminal trial. In the present charge sheet, 8 witnesses are stated to be listed. Despite the adverse materials with regard to the petitioner, the adverse circumstances with regard to the petitioner, considering the length of under trial detention and to enable him to defend himself in the trial, I deem it fit to grant him bail at this stage. Accordingly, 30,000 with one security of the like amount, subject to the conditions that he shall be available during the remaining trial. He shall not hamper or tamper with evidence. He shall not threaten, harass, or harm the informant side or any witnesses. Violation will entail bail, cancellation of bail. Return back. You can take back this. You may need it. Or should I keep it here? Should I keep it? You can take it back. I can keep it also. I can keep it here. The record. Okay. Allowed, bail petition allowed in this post.
Time being item 3.
I need it.
May, Mr. Lordship.
Yes.
Anticipatory bail application, Lordship. FIR page 16, 160. Allegation under section 10 or 310(4), Lordship.
Page
16.
16.
Petitioner is the FIR named accused number 4, Lordship. Original.
Nice.
But there is no specific allegation against the petitioner, Lordship.
Any pending bail applications, any other bail application pertaining to the FIR present on, fixed on another date? Because we can fix it on the same date.
So for my information, Lordship, already 4 disposed of, 3 petition disposed of, Lordship.
Dispose.
Yes, Lordship. At present, no pending case.
এইটো তাৰ পৰাই ল'ব লাগিব বেলেগ এটাৰ পৰা allegations to ল'ব লাগিব তাৰ পৰা
Friday, man, we take a son, man. Otherwise, there are subsequent materials.
you have received
No, man, on
Ah.
Friday, man. If
Friday.
you want to sort it, otherwise, it will go after vacation.
Friday, you want it Friday or after vacation?
Maybe Friday.
Friday, but
Take a son.
what? Call for the
Then
case diary
Lordship,
of
after vacation, Lordship, immediately after.
immediately after vacation. Call for the case diary of Bongaigaon PS case number 290 of 2025 on 5th reopening
Yes, my lord.
5-1. No, we are reopening on second, so. but-
Let it be on sixth one,
Hmm.
six my lord,
Second is a holiday since,
six one.
6-1, okay.
Obliged.
Number 12,
May I please? Well, this is also an application for the bail. The petitioner was arrested. Today is 101 day.
Oh.
Custody already, my lord, this charge sheet has been submitted. PCR was called for, my lord. Now, in this case,
Commercial quantity, huh?
my lord, the 324 grams of heroin allegedly been recovered from
320.
2%, my lord, not from the petitioner.
Okay.
One, my lord, 2% is on a specific information, my lord, one Johorul and Joinal. From 2 persons motorbike, it has been recovered, my lord.
Mhm.
It is on FIR value 25/5/2025. After 3 months of this recovery,
Hmm.
I was arrested. I have been picked up from my residence on the basis of the co-accused statement as far as the forwarding report. And there are prior telephonic conversation between me and the co-accused. That is the alleged forwarding in this case, madam. Well, in the now that thereafter, madam, the charge sheet has been laid down in this case, madam.
Hmm.
But apart from that, madam, the co-accused statement,
Hmm.
there's only material against me, as they have projected earlier, that there are some conversation me with the co-accused telephonic conversation. But in the charge sheet, lordship kindly see it starts from the page.
30, I think.
Wait, my lord. The charge sheet starts from page, my lord, 30, my lord, and they have not relied page 34. Any CDR report, my lord.
Mhm.
Page 34, the particulars of the document cited and called upon. There are 15 number of document, but there is no CDR report.
Video report. Yes.
Now, on the base, the lordship will kindly see there's a one order. Page, my lord, 42.
43?
42, my lord.
42.
He is another co-accused, Abul Hussein, my lord, who was granted bail by this honorable court,
Hmm.
considering the fact that he was also implicated by the co-accused statement. That will lordship will find. Paragraph 5.
Hmm.
Page 43.
Hmm.
To ensure learned public prosecutor state respondent on perusal of the case record submits that there are enough material against the petitioner to the effect that the messages are retrieved from the cell phone of the petitioner, which shows the petitioner was involved in the said business of dealing in drugs. He also submits that the co-accused has named the petitioner in clear terms as a petitioner in the said drugs business. So and so, now paragraph 7. It has been seen that the police person has arrested two accused person, namely Johorul and the Joinal Haq, which he contravenes during the raid being made, and it was Johorul Haq who named the petitioner. As such, this is important. As such, the statement is of the co-accused.
Right.
The messages received from the cell phone of the petitioner is also not very clear as to whether it was about the contraband. So accordingly, my lord, as it was only the implication by the co-accused, and it was not clear that the messages
Hmm.
whether it is regarding
Yes.
the contraband.
No,
or
accordingly,
bail
bail
was
was.
granted. In my case, I have a better case, but I was also implicated by the co-accused. I was arrested after 3 months of the incident, and initially there is an allegation that there is a prior conversation me with the co-accused,
Hmm.
but the search sheet shows that the no CDR been relied by the prosecution. That means there is no CDR at all
Hmm.
of mine with the co-accused. And CDR does not reveal that the content of the the messages. Only it can be seen that yes, there is a
Contents are what is most important.
yes, contents is most important, my lord. Now,
Prima facie, prima
facie,
facie.
my lord. And
Conversations, because nowadays everyone is on the phone. Because so conversations in the backdrop of such an allegation could raise some suspicion, but to make it go further, we have to see the context.
sir.
What kind of conversation?
yes. So, my lord, and lordship knows, my lord, that in the Tufan Singh judgment, my lord,
Hmm.
that the co-accused statement is not admissible, and subsequently there are few judgment, and the one judgment has particularly has distinguished that the yes, co-accused statement is not admissible in cases of when the person is arrested or in the custody. But
Hmm.
in case of when in anticipatory bail, pre-arrest bail, the co-accused statement can be relied on, my lord.
Also, is it?
Yes.
Hmm.
Tufan Singh has been relied by the Chaudhary Khan.
Otherwise, it is in the trial only as you know too well. Co-accused can be used during the trial, but it requires corroboration.
Corroboration.
You know,
Section
accomplice
30,
evidence.
yes.
But to not say
benefit of
only
the-
conviction cannot be based on statement of co-accused. That is very sound law. You know, because the credibility of a
Witness, my lord.
accomplice
Yes,
evidence is less.
very less.
Nowadays, now in BNS, BSA, it has been the language has been made more clear, right? In BSA now, no new evidence.
Mm.
Anyway, so this is
The
what we
paragraph
take
8,
from
my
the-
lord. This is also person in the custody.
Paragraph 8. In a
Yes.
case of this nature, the respondents may have to take advantage, may be able to take advantage of perhaps at the time of arguing regularly to conclusion. So, yeah, so 8 and 9 also. So,
Yes.
in anticipatory bail, this has been indirectly held to be not applicable.
Yes.
Seems so. From the language, it seems so.
And the initial forwarding also
No,
not
no.
implicated me, in the subsequent only
So,
they have implicated me. That's all, my lord.
okay.
My lord, I have gone to the scan copy of the records, my lord. Now, my lord, I'll take your lordship to my lord, page number 38, my lord.
Page number 30.
38 of the bail application, my lord.
38,
The copy of the search sheet, my lord. Lordship may kindly come to my lord, paragraph number 5, my lord.
Paragraph number
5. Further, during interrogation, accused Joinul Haq and Zohrul Haq, my lord, these are the two persons, my lord,
who are
from whose possession, my lord, the contraband was recovered and arrested, my lord. Now, my lord, when this person was arrested, my lord,
Hmm.
then there has to be some interrogation, my lord. Without interrogation, my lord, then police will have to stop, my lord, after arresting.
There has to be interrogation.
So, my lord, they were interrogated, my lord, and they have revealed these two persons' name, my lord. And lordship may kindly come to next page.
These two person or one person?
No, two persons, my lord.
One who was granted bail, my lord.
My lord, that
No, no.
person was
Can you-
granted
can-
bail,
can-
my lord. Lordship may-
Can you
Yeah,
read
I'll come to that also, my lord.
can you read paragraph
Yes,
5 on
Paragraph 5, my lord.
complete man. Further during investigation.
During
interrogation.
investigation, Joinul Haq and
Interrogation.
Zohrul Haq revealed the involvement of the another individual named Semim Ahmed Tapadar. This is the petitioner, my lord,
Hmm.
in the sale and distribution of drugs.
Hmm.
Following this disclosure, the following accused persons were arrested and forwarded to judicial custody on 26/5/2025. Zohrul Haq, son of so-and-so, and my lord,
So-and-so.
another is my lord,
Abdul Hussain.
Joinul
Three
Haq, son
persons.
of so-and-so,
3
and
persons were
Abdul
arrested.
Hussain, my lord. Lordship may kindly see number 3 is the Abdul Hussain, my lord.
Hmm.
Abdul Hussain, village so-and-so, Sribhumi. Now, Lordship may kindly come to page number 39, my lord. Next page, my lord. My lord, who is he, my lord? Yeah. Abdul Hussain, my lord, who was granted bail by the Honorable Court, my lord.
Page?
Lordship may kindly come to page number 39, my lord.
Hmm. Para
serial number 12, my lord.
12.
Yes, thereafter I received an order from the Honorable SSP Sribhumi to accord prosecution sanction against the accused person Abul Hussain, son of so and so Assam, to prosecute and for commission of offence under section. But he is a police officer, policeman, my lord. My lord, while granting bail, whether my colleague, my lord, it was, my lord, that was pointed out to this honorable court or not, I do not know, my lord. But
Police
being a police officer, my lord, they arrange customer, my lord, this Semi Mohammed and this Abul, he being the police officer, my lord, because they get all the information, my lord, and they forward this information, my lord, to this peddler, my lord, who was arrested along with the contraband, which is commercially in nature, my lord.
Hmm.
So when the police officer was
Now, my
granted
lord,
bail, my
after,
lord,
my lord, let me complete, my lord. Now, my lord, after arresting, my lord, these two persons, my lord, there has to be some interrogation, my lord. Now, my lord, they have given that these are the person also involved. They have gathered up the information and the prospective buyer, my lord. In this regard, my lord, I'll take your lordship again to page number 37, my lord. Not 37, 38, my lord. And lordship may kindly come to serial number 7, my lord. During investigation, CDR requisitions were sent for the mobile numbers of the accused person, my lord. That means Zohrul and Joinal and Abul Hussain, my lord. And also, my lord, Semi Mohammed Tapada, that is the petitioner, my lord. Frequent communication was observed between Zahirul Haq and Abul Hussain on 25/5/2025, prior to the interception of the vehicle and seizure of drugs. Abul Hussain also had regular contact with Semi Mohammed. The CDR data corroborated the statement of the accused Zohrul and Joinul Haq, thereby establishing a network between the Abul Hussain and Semi Mohammed in the drug trade. On 25/5/2025, prior to the interception of the vehicle and the seizing of the drug, Semi Mohammed Tapadar and Abul Hussain were frequent communication, my lord. But these are the materials, my lord, because it's an organized crime, my lord. There cannot be any direct evidence, my lord. Now, my lord, after arresting two persons, my lord, along with a commercial quantity, my lord, there has to be some interrogation, my lord. And my learned friend has submitted, my lord, only on the basis of co-question. Yes, only on the basis of co-question. But what are the investigation reveals, my lord? Also, one of them is a police personnel. This is very serious in nature, my lord.
he was granted bail.
Granted bail, that was not pointed out to this honorable court.
No, my lord, that was, he cannot argue that, my lord, that it was not pointed out, that it will go, we have to go by the honorable court's order.
And in this NDPS case,
The-
my lord, the parity will
No.
not come, my lord.
I am not asking for the parity, the law, parity on the facts. Parity of the law is different. Parity of the law will always prevail.
See,
I am on the parity of the law, not on the facts.
see, the thing is that let's be clear. To decide this, what we'll need is that it's very clear that what are the materials. Since investigation is completed,
Yes.
now we are in a better position to apply the broad principle of Tufan though that is applicable at the stage of trial. But with regard to bail, at the stage of completion, after completion of investigation, we are in a better position to apply that principle. Now we have to see that, yes, what are the incriminating materials against the petitioner? Statement of co-accused. And apart from the, just focus on that. Apart from the statements of co-accused, what are the other materials? If there are other materials and
Yes.
suppose the court it indicates incrimination, then perhaps that can be taken into account. Since it is to determine 37, since commercial quantity is there, we have to make a determination.
Yes.
Otherwise, the discretion is more. Now discretion is less.
Page number 38, ground number 7, my lord. Serial number 7.
No, that I've seen. I'm reading this.
That is during investigation, CDR, the earlier, my lord, in the bail application, court has perused that material. In the other case, the police officer's case, who has granted bail considering the CDR report, that the CDR that does not indicate direct involvement.
Because the thing is that, but one point here, learned senior counsel has pointed out correctly that some significant points have been mentioned in para 7, right? From the point of view of prosecution. But to prove this, CDR will be necessary.
My lord, CDR is necessary, that will be proved in a trial, my lord.
No, CDR as a document.
No, the document, my lord, it is there, my lord.
Where?
But my lord, Lordship may kindly say paragraph number 7, my lord.
Yes, where
1,
is
2,
the
3,
CDR?
4, 5, 6, my lord.
Supplementary charge sheet can be submitted, that's true.
This
But
CDR
here
data
it comes to
corroborates. This
Where
CDR
is the
data
CDR?
corroborates the statement, my lord.
Yes, kindly see the
CDR
list of
data
the,
corroborates the statement of accused Zahirul Joinul Haq,
CDR
thereby
data.
establishing a network.
Can we see the CDR data? Is it there?
My lord, there, page 34, there is no CDR.
Can you get the CDR done? Because you can take, you call for
No, no.
CDR data if available.
Their data is available.
Because
No, my lord, the CDR data will see only there is a call. What does it indicate, my lord? If there is a call also.
no, this, and they can
And
also see the
logically see-
contents. They can also see the contents.
Yes, my lord.
No,
Content-
CDR, that has to be, my lord, no, CDR data will not contain, that has to be the
Transcript.
WhatsApp, transcript, my lord. That
No,
transcript,
not-
no, lordship kindly see the point number 2.
No, not only WhatsApp.
Not
WhatsApp is messages,
Yes,
data.
my lord,
Telephone conversations can
Yes.
also be seen.
No,
Only-
it has to be recorded prior to, with a permission from the
Yes,
authority
that-
concerned, my
yeah,
lord.
that's-
Lordship can, page 34,
That is true.
that has to be taken.
Intercepted communications have to
Yes,
be.
yes.
have
That
to be
has to
seen.
be, it is not an intercepted communication, my lord, colleague, 34, lordship, see, where is that CDR data they are relying on the, in the search sheet, my lord?
Because the methods of crimes have also become very sophisticated nowadays, right? WhatsApp communications, WhatsApp calls, you can say that calls are there. They indicate calls, but the contents are encrypted. The SMS, the WhatsApp communicate data is WhatsApp messages are also supposed to be encrypted.
Yes.
But often we see in investigation that all WhatsApp's data is come. Probably it is given to
That-
law enforcing agency, not to you and me.
Yes.
To probably law
And
enforcing
in-
agency, not you and me in private capacity, but
And-
as law enforcing agency.
When the phone is seized, my lord, then it can be retrieved,
And
probably, my lord. Then now lordship can
no,
see
it won't
the
be from the
34.
phone. No, it won't be from the phone. It's
34, my lord.
encrypted in cloud, I think, most probably. Anyway,
Page,
so-
page 34. He's harping on, my lord, where is that, my lord?
so I think
CDR.
it will be better to.
My lord, no, there's no CDR, lordship, my lord. No CDR. They have not relied on the CDR.
So
If
I-
that is be so, he is harping on the same search sheet, my lord.
But these are serious matters also, right? So
Oh,
we have
that's
to
it,
see the
that-
complete
that-
picture.
No, my personal liberty also.
That is
After 3 months, you will arrest me. After 3 months of the incident, my lord.
True, that
It's
true.
not a case of that I have
That
been,
is true.
then if there is a disclosure by these co-accused.
No, 37 has to be seen. No?
No,
The
that
complete
is-
materials have to be seen.
No, material lordship is before it, the lordship. The prima facie, they have not relied on the search sheet. He is relying on that there is a conversation in the CDR, and whereas that in the particulars, there is no CDR report. How can we rely on that statement, my lord?
So that's why I'm saying you seek
That
some
is what
further
I'm
data.
saying.
Then, my lord,
As on that, there is no CDR, my lord.
the report may be called for, my lord.
Yes.
So where from? Where from you will call for? Where from you call for?
From
Can you-
the case diary.
My lord,
No,
lordship can
let me say,
say-
the case diary, how the CDR report is a part of the case diary, man.
It should be part, but
No, the
is the
record has
complete
already
case
been
diary
called
is
for.
available?
No, already record has been.
That is there, my lord.
Yes, but the case diary,
In the, why they have not relied on, my lord, if that is there? Lordship has to ask
No,
the,
no, no, these
why
are
they
very
have not
serious-
relied in.
These are very serious matters.
No, Lordship has to ask the question, why they have not relied in.
That-
If they are relying on the only material, apart from the co-accused statement, is my conversation or my phone call with the co-accused, then why they have not relied on this material, my lord, in the search?
So you give me either way, I'll dispose it off, or we can call for the data, or the updated data
That I
regarding.
leave it to
CD.
lordship, my lord, because as far as my humble submission, my lord, there are sufficient
The whole
materials
trial court
collected, my
record.
lord. And this is the
I-
organized crime, my lord. Lordship may kindly say, my lord.
That is what I am
section
saying.
10 and also SARS has also
But I am not
taken
denying the
20, my
fact.
lord.
I'm not denying. My only contention is that if you are relying that apart from the co-accused statement, there are CDR reports, phone conversation with the co-accused, then why that conversation CDR report is not
should
part
do-
of the search sheet, my lord?
That's why I'm saying that will be better, right? Please write, this thing. The heard learned senior counsel A.M. Bora also heard learned. That will be fair to both sides, I think. R.J. Borwa, learned counsel. The main contentions of the learned senior counsel. I'll just write so that for reference that the main contentions of the learned senior counsel is that the only materials against the present petitioner who was arrested 3 months after the alleged recovery are the statements of co-accused. And in terms of the principle laid down in the case of Tufan Singh versus State of Tamil Nadu, citation to Silo, that aspect can be taken into account for the purpose of adjudication of bail, including the adjudication under section 37 of the NDPS Act, comma, which is required in this case due to alleged commercial quantity being involved. Full stop. Long sentence. Uh, in the context of the submission of the prosecution about incriminating CDR materials apart from the statement of co-accused, the learned senior counsel submits that in the list of relied upon documents in the charge sheet filed after the after the investigation, there is no reference to CDR. Full stop. In view of the said facts and circumstances, I'm of the considered view that the prosecution and considering the nature of the alleged offences, I'm of the considered view that the prosecution should be given an opportunity to submit before the court any materials, any other materials in the original case record and the case diary regarding incriminating telephone conversations within brackets CDR. Accordingly, the prosecution.
Maybe sent to a trial court, my lord. If the CDR is available, my lord,
If the requisition maybe
Probably, my lord,
cannot call, my lord, that will.
requisition may be sent to the learned concerned learned trial court to send to this court scan copies of the CDR, scan copies of documents / materials pertaining to CDR and telephone conversations. So when should we fix it?
Immediately after vacation, my lord. Subject to my learned senior class convenience.
Actually, these are, both sides we have to see serious matters. The police should also do thorough investigation. Thorough investigation, because they nowadays in technology, by technology, because I've seen it in this, nowadays in police is also doing CID, especially CBI, and they have all dedicated people for that. You can indicate by arrows, this spoke diagrams, how many calls, A1 to A2, A2 to A3, A4, but anyway, at least number of calls you can do. Of course, as he is rightly said, the contents will have to be on interception, which will require permission.
In the my lord, the search sheet which has been laid down, there is absolutely no whisper about this conversation and the phone number.
Yeah, that's you're right actually. So that's why
Where is
I have
that?
to satisfy myself also. So
So
that
my
is why.
Lordship, can we call for the entire record of the whatever they have?
I have given a CDR, but entire record, some part is
What?
already here.
Okay. Only CD, my friend has said only the CD has come for.
CD has come, other than the entire record we call for from the, my lord, entire scan copy of the record, my lord, from the trial court, my lord.
Is it?
Yes, my lord.
That will reveal, is there anything?
The entire scan copy of the entire TCR, including you write that, including
them on the CDR and
including this
yes,
case diary, full case diary is here.
yes, my lord.
Full
Full
case
test.
diary. Okay. Should I fix it on 5 reopening?
No.
5?
10th, my lord.
5-1.
10th.
Hmm?
No, the 10th, that will be on 10th, my lord. 5-1, my lord, may not be.
Reopening. 10th is holiday. 6 to 9. 6 to
9th, my lord.
no,
9-1, my lord.
13,
Oh, right.
May it please your lordship, regular bail application, your lordship, the petitioner is behind the bar for 153 days. The solicited case, your lordship, trial court's record has been called for. The FIR is on page 9, your lordship.
9.
Page 9. Lordship, we kindly consider the date. FIR was lodged on 28/1/2022. Then after that, he was, no inquiry was made and no police person came to his place and he neither took any bail. But he came to know from reliable sources that his case has been searched, your lordship.
Oh. When was he arrested?
arrested after 16/7/2025. Lordship will kindly
Yes, go on.
annexed Your Lordship. Annexed page number 22. He has appeared before the Sessions Court voluntarily, Your Lordship, and then he was arrested.
No.
Page 22.
Hmm.
Then after that, he was in jail for the nearly 5 months.
Girl must have been recovered.
Lordship,
Recovered.
already recovered. But if I'm only on the length of detention, 153 days, the girl is recovered, Your Lordship.
Three 76
Now we-
2N. no?
Lordship. Love affair, Your Lordship, the girl came to his place. And after that, the kidnapping case was lodged. And subsequently, she is recovered.
I'll see her statement once. "17 years. Service of
The boy is also 23 years, Your Lordship.
It is true, love affair, but he himself told her that he's married, having children.
See, it
That
is,
is why the informant father was also very offended. Anyway.
okay, it was known to her also, Your Lordship. But after some altercation occurred between the two and between the family members, the FIR was lodged, Your Lordship. 5 months behind the jail, Your Lordship.
She has been examined.
No, my lord, she has not been examined till yet, my lord. Only father has been examined as an informant, PW1.
FIR lodged on 28/1/2022, Your Lordship.
What is 376 2M? Refresh.
Charge-sheeted only under 366A, Your Lordship.
Only on that?
Only page.
No, I think, no, charge order.
No, Sarge frame, my lord, 366 and 376 2HN, my lord.
N. Oh, it's repeated. Rape.
See, page 20 of the charge sheet in the
Repeated
petition.
rape. 10 years. No, it's a very stringent offense. It is minimum 10 years. Repeated rape. Have you seen the statement of the girl?
Yes, my lord, absolutely.
Yes, you can also submit, but some parts of the handwriting are slightly problematic for me, but I've read it broadly.
I have seen, my lord, she said that, my lord, he knew him, my lord.
HR
And there was some kind of love affair, my lord. But on that day, my lord, she was taken forcefully, my lord. And physical relationship were established forcefully, my lord.
That is what she
It
has
is the
said.
allegation, Your Lordship.
I see there are more
It is
inside.
the-
Again, she has said more than once.
It is
Hold
the
on.
allegation, Your Lordship. It was a mutual affair.
But the problematic part is, madam, as you seen that if he was already married.
Five months behind the bar, Your Lordship.
F. Hussain Learned Council and R.J. Bora, additional people, full stop. The allegation in the FIR dated 28/1/2022 No, it was lodged in 22
22.
and he
Your
was arrested in 25.
25,
How
Your
come?
Lordship. Lordship, after the lodging of the FIR,
Oh,
he was not arrested. Your
sorry, sorry.
He volunteered.
28 1 to, yes, yes, I forgot. 28 1 2022. So, do you think the victim, that's the only issue? Should you,
Yes.
otherwise length is, it's already there. Seriousness, it's there. Very serious offense, minimum 10 years. But the victim is not examined.
Not
That
examined.
aspect is there. Otherwise, 376(2) is minimum and non-remittable life sentence is also given. 376(2) non-remittable, no, that means whole life. In
Without any
jail.
remittance.
This is a non-remittable life sentence.
After the lodging of the FIR, he was not arrested, Your Lordship.
The police investigated from the point of view of 366A actually.
Yes.
A charge was framed under that. Anyway, with the allegation that the 17 years old daughter of the informant went missing. And later, it came to be known that the petitioner had taken her. Full stop. The case was investigated, during which the statement of the alleged victim girl was recorded. And the same is available in the scan case record received. Full stop. In her statement, she has stated about her initial love affair with the accused, but subsequently stated that he forcefully took her away and committed physical relationship upon her forcefully. And in the house of the accused, he came to know, and later she came to know that he was already married with children. Full stop. The learned petitioner counsel has contended mainly on the length of detention. Since the date of arrest of the petitioner on, what is the date of petitioner arrest? 16/7/2025. Charges have been framed by the learned trial court under 366, 370, 376 within bracket 2, within bracket small n IPC. Full stop. So far, the informant has been examined, but the victim girl has not been examined. Full stop. In the given facts and circumstances, the bail petition stands rejected at this stage. Full stop. Bail petition stands rejected and disposed of accordingly. We'll see after let the victim be examined.
Obliged.
Disposed of.
14.
My pleasure. It is section 22B close to 3 of NDPS, Your Lordship. Total custody 1 year, 4 months, 17 days. Paris page number 10. Allegation 24.5 kg ganja recovered.
Therefore, C, 20 C has been given, right? Page number 20.
10 euros.
No, okay.
Lordship,
Yes, tell me, submission.
on last 4th December, 2 witnesses examined, Your Lordship.
So
2
far,
witnesses examined
2 witnesses,
on 4th December, Your Lordship.
2 witnesses.
Witnesses only. And
Any
both the
idea,
witnesses
do you know how many are
Constable.
listed in the charge sheet?
Lordship.
Do you know how many are listed in the charge sheet?
Yes, total 8 witnesses, Your Lordship.
Much.
There 4 witnesses are police personnel,
Hmm.
3 Caesar witness, and 1 is some test
Mhm.
special report. He is a local person, Your Lordship. Total cost 1 month, 1 year, 4 months, 17 days. And my second ground, Your Lordship, grant of arrest not communicated, Your Lordship. Reason of arrest. There is a green flag mark, Your Lordship, kindly be perused, Your Lordship.
Here, in the scan record,
Yes.
will come. Ground of arrest. Those witnesses. Arrest memo. Only this much. Okay, can I go to him? Yes.
Otherwise, I am going through my lord, but in getting the ground of arrest,
Mm.
I have to go through again, my lord.
Kindly see, only this much will not do, obviously. Because it is a July 24. By that time, by these things, July 24, well, July 24, it was not so clear at that time also. Kindly see, this will not do, but only thing you have to see is whether there is any other component.
Any other regarding, my lord, other materials, my lord, we,
No, any other component of this.
my lord, that I'll go through. my lord.
Sometimes it is on the other sheet, right?
That is, my
Sometimes
lord,
it is on the other sheet also. Kindly have a look.
at 2 p.m. my lord,
Yes, after some time,
2 p.m.
2 or whatever, after in the second half. Second half.
15,
Just a minute. Good action.
Yes, Lord. My lord, regular bail application, my lord. There are two petitioners before your lordship. The allegation is that, my lord, the police on some secret information, well, phase 10 is the FIR. On some secret information, they searched the house of the rented house of the petitioners and recovered suspected peg gold.
Fake gold.
Peg gold. It is suspected to be peg gold. That is phase 10. Now they are in judicial custody, my lord, since 28 days. And the section incorporated here, my lord, the criminal breach of trust and sweeping. And there is no such information, my lord, received by the police that they have cheated someone, my lord.
Mhm.
My lord, they can say the petitioner has violated the provision of, my lord, BIS, my lord. They have not cheated anyone. And the penalties under the BIS, my lord, only 1 year imprisonment and fine of ₹1 lakh, which can be extended up to 5 times of the value of the items, my lord.
Fake gold selling racket. This thing, anyway, we'll see.
My lord, the section incorporated here is cheating, my lord. Whether they have cheated anybody, my lord. There is no such information. There is no information registered against them, my lord, in any of the police stations, my lord. And secondly, my lord, the petitioner number 1, my lord, his wife, she is pregnant, my lord. They reside in the rented premise. And the date of delivery is, my lord, coming in the month of February. And there is no one to look after her, my lord. Only the petitioner number 1 and she living in a rented premise. And now he is in custody. This aspects, my lord,
Okay, sir.
considering the length of
Okay,
detention
sir.
also, already 28 days, my lord.
Anyway, so
Yeah, we did the case, and my lord, I take your lordship to the FIR, my lord. My learned friend said, my lord, they have not cheated anybody, my lord. So, lordship may kindly peruse the FIR page number 10, my lord. With reference to the subject cited above, I, SI Akajudi Soikia, beg to report that today on so-and-so at around 11:20 AM, a reliable source information was received from a source that some unknown person are dealing in fake gold in a rented residence situated at so and so. After receiving the information, OC Hatigaon PS was informed and GD entry was entertained by Hatigaon PS number by GD entry number so and so, dated so and so. Accordingly, I, Jotin Pek Tahu, along with the PS staff, promptly proceeded to the PO. Upon arrival of the PO, a house search was conducted in the above mentioned residence in presence of the independent witnesses. During the house search, one hard piece suspected to be fake gold weighing 614 grams is recovered and seized from the possession of Abdul Barek and my lord Ariful Islam, my lord. Now, my lord, my learned friend has submitted, my lord. They have not cheated anybody.
So fake gold
Abdul Barek and
For
Arif,
what purpose, my lord? They have
Abdul
fake
Barek and
fake
Ariful,
gold.
they are my lord. the petitioner.
suspected to be fake.
Yes, my
They have
lord.
to be examined.
Yes, that to be examined, my lord. And
No, no,
FSL
that gold can be examined, whether
Yes,
it is
my lord. It
counterfeit.
has been sent for FSL examination, my lord. The
I see.
report has not received, my lord. I don't get.
And is the investigation, has it revealed any involvement of bracket, something of that sort?
Yes, my lord. Even my lord, the accused person, they have also stated, my lord, that they have. So this
Apart
it
from
was
that,
delivered by one person, my lord. That person is yet to be arrested.
apart
They have
from,
named this person, my lord.
apart from that,
Yes,
generally.
my lord.
No, no, apart from that, other materials,
Apart
apart
from this,
from
my lord, the investigation is happening.
going on.
We will cooperate with the investigation, my lord. Now 30, almost 30 days, my lord.
Third, M. Ali Learned Council and Rajay Bora additional people. Stuff. The two petitioners herein were arrested on 19/11/2025 in connection with 18/11/2025
1811.
in connection with Hatigaon PS case number 202 of 25 under section so and so. The gist of the allegations in the FIR dated 19/11/2025 is that, no, it cannot be forwarded. No, the allegation. Where is the FIR is the page?
FR page 10. now.
Page 18/11/2025 is that source information was received about involvement of some persons in dealing with fake gold. Whereupon GD number 12 dated 18/11/25 was made in Hatigaon PS, and search was conducted in the residence at the aforesaid residence of the accused petitioner Abdul Barak, and in the presence of witnesses, gold suspected to be fake weighing 614 grams was recovered. Full stop. And Ariful Islam, both from both. From both? Okay. It was seized from both. Full stop. In the grounds of arrest at the time of forwarding, it is stated that the accused persons are involved in selling of fake gold to persons, and that a fake gold selling racket is active in Guwahati and other parts of the state, and for which investigation is being conducted with a view to dismantling the nexus. Full stop. The learned petitioner counsel submits that considering the length of detention, there may be granted bail.
And also considering the medical.
Full stop. With regard to petitioner number 1, namely, it's some time away, but still. Petitioner
Under
number
any condition, my lord, we will cooperate with the investigation.
Abdul Barak, it is submitted that his wife is expecting a delivery in the month of February 2026. Here is the relevant document. The learned additional PP opposing the bail submits that the suspected fake goal has been sent to the forensic for investigation. And the investigation, including the statements of the accused persons, have also lend support to the allegations about uh, about involvement of fake gold selling, fake gold selling activities, and investigation into the involvement of other persons is also being looked into. Forensic analysis has to be awaited. In the given facts and circumstances, the investigation is also the instant bail petition is rejected at this stage, returned back the case.
Not at least the petitioner number one.
For some time, it's up to February. After some time, you can file in January again. By that time, it will be completed. Investigation will be completed.
My lord, my lord may observe at this stage, my lord.
Always at this stage. Always it is mentioned. Rejected at this stage. Always like that.
Section
Regular bail, especially always like that.
Obliged.
The 16 searches submitted, my lord.
What is the allegation?
Election lordship under section 70, subsection 1 lordship. Investigation has already completed lordship. The matter is committed to the session court lordship, and it is fixed on 1912 lordship. And copy of the case record is already furnished to us lord.
Would you approach the learned trial court?
No, it is pending before this.
No, for regular bail there.
No,
Because the allegations are, what are the sections given? Because the allegations are of, what did the allegation about repeated rape,
gang rape lord.
Hmm?
Gang rape.
gang rape?
Lord.
We'll have to see. Either you can approach there or we'll have to call for the scan copy.
Lordship, I have to records of the case lordship. It is furnished to us
Is
lordship.
this-
By the
Because this will be covered by a very serious section.
I look at the statement of lordship recorded under section 183 lordship.
Yes, I can. see that.
For a moment, lordship.
I can see that.
Lordship.
Where is it there? Have you annexed or something?
Lordship,
What's it? You have a
this is-
certified copy? Yes, I'll have it.
It's furnished to us by the Lordship court below. Lord.
Give me, I'll have it.
Free copy lordship furnished to the engaged counsel of the trial court lordship. Lordship will find it page 10 lordship. Statement under section 183.
Yeah, she said that, but have a look at this statement also.
Last part is important lordship.
Can we, but we have to, I think, get a. Deduction. Yes. This is the original certificate copy, right?
Lordship,
Original certificate, copy.
supplied by court, Lordship.
Supplied by the copies.
Right.
Just give it to the learned people. Have you received the case there or only the intimation?
Intimation, yes, sir.
Only
We have
intimation.
issued the intimation, only
Uh, Can we have, just have a look? Can we go by this or we need some more materials?
Medical reports are also important, but point to it.
It's an oath before a magistrate.
Hmm?
It's an oath before a magistrate.
Yes, yes.
Next date is 1912.
So she falsely stated that it is,
Yes. But
And-
we have intimation that charge subject, but section is not in.
no, in the last part of the
Yes, I think. so.
statement, can you,
Last part of statement, yes, see, he has stated that he has falsely implicated the petitioners.
that's very bad. Due to being, but she was, what was the allegation? They took her away forcefully.
Yes.
And,
Took her away forcefully and later part in the raped her.
no, in the statement.
Statement, her took her forcefully and demanded rupees 15,000. And taken
Net
up,
zero.
net
Net
15,000 rupees from her. And she fled away from the place of that place and went to the police station. And when
He was, I'm being afraid in.
Bengal, he has stated that he was raped.
Mr. D.P. Goswami learned level extra. D.P. Goswami learned additional PP submits that in the meantime, the instant case that is Jonai PS arising out of instant bail application. Sorry, in the concerned police case that is Jonai PS case number 90 of 2025 under section 70 within bracket 1 BNS has been charge sheeted. Full stop. The three petitioners herein are seeking bail and they were arrested on 23/10/2025. The allegation in the FIR was about snatching of money from the victim and commission of rape upon her. Full stop. The learned counsel for the petitioner has submitted a copy of the statement recorded before there is a copy of the statement of the victim recorded on the 183 BNSS and containing that it is the copy which has been furnished to them under 207 CRPC. What is the equivalent section? TD4 BNSS 207 CRPC earlier BNSS BNSS. Full stop. The said statement is also perused by the learned prosecution. Full stop. In the said statement, from the in the said statement, the informant / victim has stated that rupees 15,000 was snatched away from her by the petitioners, and she has stated at the end of the statement that at that time she was angry and therefore she also stated that these persons have raped her. Like that, she has raped her.
Tried to rape her.
Huh?
Or
Tried to
well,
rape her.
tried to
Tried to rape her. Very bad. How can you say that? Just because you are angry. You release your anger somewhere else. Anyway, so prima facie crime is against women, but we have to see both sides. In view of the aforesaid facts and circumstances, and also the completion of the also the length of detention as well as the completion of investigation dash, the accused persons are allowed to go on bail of rupees 25,000 each with a surety of the like amount each to the satisfaction of the concerned learned court and subject to the conditions in number 1, they shall be available for trial if one commences. Number 2, they shall not in any manner intimidate, harass or harm the informant victim informant. They shall not hamper or tamper with evidence. In case of violation of bail conditions, the bail will be liable to be cancelled. That's true. The bail petition stands allowed and disposed of.
Deeply obliged, Lord.
Take just 5 minutes.
46 BNS and 47 BNS police has not been followed, Lordship.
Just let me see the FIR first. Scan copy has come. The elder brother Konesboro went to do it. Don't put it here. Injured him. Murder case, right?
Yes, Lord.
302. Anyway, whatever it is, he was arrested on.
Arrested on Lordship 10/9/2025, Lordship. Forwarding on Lordship 11/9/2025, Lordship.
3 months, more than 3 months.
Lordship petitioner is ready to face the trial, Lordship. Kindly consider the bail.
You mentioned something about the the notices.
Yes, Lord.
What is it here?
Yes. I have not annexed there, Lordship.
It should be in the record. In the record?
Police did not give the notice and arrest of ground is not informing the petitioner, Lordship.
Could you see the record?
Last this I had found
No.
not sufficient, but sufficient also there are because if you check the branch.
If you have not given to the, there will be nothing.
Branch of arrest they are lost.
Mhm.
Back to my.
EM report.
I have taken it down.
Mr. PK Gogoi and DP Goswami learned additional people. The allegation in the Azahar is about the petitioner assaulting the brother of the informant and injuring him with a sharp weapon. It appears that subsequently the victim expired, right?
Yes, Lord.
Whereupon section 302 IPC was also added. The petitioner was stated to have been arrested on 10/9/2026. Investigation is completed in the case by way of a charge sheet, and the case is presently at the stage of consideration of charge. Full stop.
There 47 notices, the grounds of arrest, Lordship, yes, specially mentioned, you are arrested because the offense is non-bailable to police. If you are not arrested, you may not appear before the honorable court.
This
You have voluntarily caused grievous hurt by sharp weapon to the victim as a result victim,
yes,
succumbed at AMCS Dibrugarh.
Hmm.
You arrested for proper investigation for the case. You are sufficiently, and 48 notice
That's
also sufficiently explained, your Lordship.
With regard to a contention of the petitioner side, the learned prosecution submits that notices at the statutory notices and record to be given at the time of arrest were duly given. Full stop. However, considering the length of detention and the completion and the fact that the case is poised for commencement of trial, I am not the considered view considered view that subject to suitable conditions, the petitioner can be enlarged on bail. Accordingly, in such view of the matter, allowed to go on bail of rupees 30,000 with 1 security to satisfaction of the concerned learned court. This is which district is that? Dibrugarh.
Dibrugarh.
CJM Dibrugarh. And subject to the conditions that he shall be available for the trial, he shall not hamper or tamper evidence, not harm or harass the informant side or any witnesses. Violation. Petition stands disposed of.
Highly approved.
Yes, the learned additional PP objects to the grant of bail at this stage.
Highly approved.
19.
May I please, your Lordship?
Yes.
483 application, Lordship, petitioner was arrested on 14/11/2025, Lordship. In this case, he is inside the jail for about 32 days, my lord.
This this
Number 1.
But
No, no.
that was rejected, your lordship, earlier occasion. This is the fresh
Lordship,
case, my lord.
Pick the case on Friday.
No, no, this is, no, no, this is,
This is fresh case, my
this is
lord.
Mr. Bahadul Islam.
Yes. They are
Ah.
going to-
This is Samir Malik.
Samir Malik. This is Samir Malik and as well Barul Islam.
Okay, oh, so this is a copy.
Oh, that day, my learned friend has supplied that copy, lordship. So lordship, here in this,
Yeah, this one, it was rejected by this
it
one.
is rejected by your lordship.
Anyway, so.
This
we
is the
fi-
fresh case, lordship.
Yes, yes, I got it.
Lord.
We are fixed on Friday. Wait.
My lord, he is inside the jail for about 32 days, my lord. Mandatory period is 60 days.
Yes.
So my lord, during that period, I think lordship, to my information, lordship, investigating officer at no point of time made him lordship. So that, for that reason.
No examination in jail custody.
Lordship, that is why lordship, all the documents is, the case is based on the documentary evidence, lordship. So my humble submission before this honorable court, lordship, all the documents seized. So his custodial interrogation or custodial detention is not required at all, my lord. With any stringent condition may pass any order.
Lord
lordship.
S.K. Nargis, Land Council, and C. Kayal, Standing Council, Revenue, GST. Full stop. It is fairly submitted that earlier bail petition was rejected on 5/12/2025, as by this court in BA 3839 of 2025. It is contended by Ms. Nargis, Learned Counsel, contends that as per her instructions during this period, the investigating officer has not examined him, petitioner in custody, and therefore perhaps further detention may not be necessary. And that the case is also based on documentary evidence. Nevertheless, call for the updated case diary, list the matter on Friday. 19, along with BA number, so and so. Item number 1. Item number 1.
My lord, my one is fresh one, lordship.
Huh?
My petition is fresh one, my lord.
No, no, no.
As your
Yes,
lordship
yes.
rejected earlier
No, no.
case, lordship,
Ah.
this is why this.
First, yes, yes. No, no. This is also a subsequent bail petition. It's been fine. Item 1.
Item one is the
Same,
second.
same FIR.
Lord, same.
Same. That's along with BA 4040 of 2025. Both are new.
That in that petition, learned senior counsel has raised that 35(3)
Yes, yes.
has not been complied with properly. Along with that, lordship, my contention is that the custodial detention is not,
Oh.
not required.
No,
lordship.
I'll see that notice also. For you also, I'll see that notice if necessary. Okay, that is my duty also as a court.
Yes.
Bring it, all the materials. I will see the
Instead
notice
of-
aspect for you also.
Lordship, instead of 19, I'll inform him, lordship, instead of 19, can it be on 18, lordship?
So 18 I will be now.
Yeah, he had mentioned. See, he'll be just back from Itanagar. He'll be on the way from Itanagar. 19. We'll do it. Or,
20,
Lordship. Here in this case, the petitioner is custody for last 45 days, Lordship. What has happened, Lordship, this one person, Dr. Abhijit Neho, has lodged an FIR alleging that the petitioner is not having a valid certificate with regard to the practice he's doing at future, Lordship. Now, what has happened, the case has been registered under these certain sections which are all bailable. Except one section, Lordship, which is only the criminal breach of trust. If your Lordship kindly see the case which has been registered. Except the sections, Lordship 3162 of the BNS. This is only the criminal breach of trust, Lordship. But if your Lordship kindly see the contents of the FIR, I'm just referring to the FIR. It is at page number 14. Page number 14. There is
yes,
nothing-
I'm on 14.
Yes, there is nothing on record which would show there is any criminal breach of trust, because the provision of criminal breach of trust is very clear, Lordship, that there should be some sort of entrustment, and there is nothing like that entrustment. Only thing is that I'm having a certificate which they have verified, because the certificate is from Kolkata. If your Lordship kindly see in the FIR also, they have specifically mentioned the serial number, registration number.
Yes.
Within bracket it is Kolkata. So they verified it from Assam. So Assam, they will not get this particular certificate verification, Lordship. So based on some sort of suspect, Lordship, this petitioner has been put behind the bar for last 45 days, Lord. They have not received the case diary.
Hmm.
Lordship, this is,
What does it say? Investigation.
no, they have not
Hmm?
received the case diary. Lord.
Oh, not.
Because this statutory period is 60 days, Lordship, it's 45 days already over, Lord. And these are all documentary.
So
evidence.
we'll have to get it within this week.
Yes, exactly, Lordship. Lordship kindly consider his bail, Lordship. So
Within
these
this-
are all documentary evidence and they have verified from Assam. They have not
Criminal
verified
breach
from
of
the-
trust, it may not be, but
Exactly,
it
Lordship.
may be cheating.
These are all bailable offense, Lordship.
Cheating,
These
it
are
may
all
be
bailable
cheating.
offense.
Cheating, it may be cheating.
If I'm not having the record certificate, this medical counsel as per the mention in the FIR, the medical counsel certificate, then also these are all valuable offense losses. But the cheating, the criminal breach of
So
trust.
they have
is-
given
The same kind of allegation.
Criminal breach of trust is no applicable. in
public
this case.
safety and yeah,
These are all valuable offense losses.
cheating,
Cheating,
public safety, which was invoked during COVID, right? This is the
Exactly.
bailable offense.
these are all valuable offense losses.
Cheating,
Except 3162 lordship, others are all valuable offense.
cheating may be there, If indeed somebody does like that,
Criminal breach of trust.
that may be criminal breach of trust.
Exactly, lordship. If the
Not,
criminal breach of trust is-
no, we should not confuse it with the trust that a patient reposes in a patient doctor. That is different. That criminal breach of trust is different. There has to be initially there has to be a legal transfer of property.
Exactly, lord.
property.
Exactly.
Anyway, so
Last day, lordship.
kindly get the case diary. I'll prefer more matters on 18th rather than overloading on 19th.
Exactly, lordship.
Because everyone has to get the orders also, right? So fix it on 18th if
18th.
possible, but it's coming from Silchar, I believe. That is the thing, a little far.
Because
No,
outside
no,
the state very
electronically
place-
not far.
Yes, lordship. They can do it, lordship,
No,
if they wish.
The case diary is not yet received. The learned counsel contends that as on today, the petitioner is in detention since for 45 days.
Yes, lordship.
For my memory.
Fix on 18th,
This is
lordship.
the matter on 18/12. If it comes, very good. Issue fresh requisition for the case there. I have no problem, but if it comes, it is good. Otherwise, it will be late.
21,
But I am behind the work since 35 days, my lord. Out of the same forwarding report, my lord, all other requests are granted bail, my lord.
Give me one.
We have not
please.
received the case diary.
On 12/12 granted bail, my lord. Out of the same forwarding report. Detention may not.
I got this. No.
It's no in 12/12, right?
My,
When can you get it? This is Hajo piece.
And 18 lordship.
Case diary is not yet received. Issue fresh reminder.
my lord.
Accused, no,
This
it's
is from
not.
Hazu, my lord.
No, it will not
I'll
come.
communicate today lordship, then.
It will not
we
come
do.
through.
Already all the co-case persons granted bail, my lord.
True, but thing is that difficult to give interim considering the allegations. Anyway, let us take a chance on 18, then we'll see. Hmm.
Everything recovered.
Anyway, so
The loaded vehicle.
the learned petitioner counsel submitting the relevant copy, order copy dated 12/12/2025 passed by the learned JMFC Hazo. Submits that other co-accused have been granted bail and the allegedly stolen materials have also been recovered first. And submits that perhaps the continued detention of the present petitioner is also not necessary. For my reference, I'm just writing this. So we'll take a chance on 18th, huh? List on 18.
Highly obliged.
supplementary 51,
Yes, sir. Go on.
With your lordship. On last order lordship, my submission was recorded lordship. There is violation of Arnesh Kumar judgment and DK Basu judgment lordship.
Recorded. He's 18 years old.
18 years.
18 years. What is the allegation?
The allegation is.
Diary has been received?
Yes, there is.
No problem. Then we can dispose. Not Guwahati PS.
Case 22.
Robbery at night. Robbery at night.
Made clear lordship.
I have seen the FIR. I've seen the FIR. Gold jewelry. So and so, so and so, so and so.
allegation is in the page 22, Lordship.
22
Lordship, notice
notes.
the detailed grounds of arrest in the last portion, Lordship.
Mhm. Yes, sir.
You are found involved with the offense. You are directly in contact with Abdul Quddus, who is the receiver of the stolen items regarding the case. In presence of police, you helped Abdul Quddus to escape from the place. Your interrogation regarding the case is much necessary. The case is non-bailable in nature. Notice under section 35(2) could not be served because you will hamper in investigation of the case if you are not arrested, Lordship. Which is mandatory under section 35(2) notice to be served.
No, mandatory grounds have to be given if you're not giving notice, right?
Lordship.
Yeah, that's
And
good.
A person, my lord, who is my lord, try to my lord, play away, my lord. You can notice this served to him,
No, no,
whether
that's
he will
fine.
appear, my lord. Because this is a very
Giving practical
cognizable offense.
realities.
This is
It's
a case
good.
of cognizable offense, my lord.
No, it's good. It's very good that
My lord, how can a thief, my lord, can be given?
people
a
should not
notice
be arrested unnecessarily. So that is why these things have been made.
Where it is
It's good.
required, my lord.
When
Where
it is required, it has to be
yes.
arrested.
Where it is not required, my lord, why notice will
Sure.
be served, my lord?
No, because it was found that many were, as you know too well, there were many unnecessary
medical-
arrests in our criminal justice system. Therefore, all these things have been tightened.
Only, my lord,
We should
under-
follow it,
that is
that's
very
all.
clear, my lord. Only, my lord, only in those cases, my lord, where arrest is not necessary, my lord. In this case, my lord, this is a cognizable
Yes.
offense, my lord.
Arrest is not necessary, and that determination has to be judicious,
Judicious, my
right,
lord.
by the IO.
Yes.
It's not that only we do.
That is absolutely correct.
We are expected to function judicially. All of us.
The petitioner wants, my
All of
lord,
us.
his client should be given notice, my lord, so that he can play away, my lord, on the spot.
And also, Lordship.
That's okay. No, what is the investigation? So we'll
Investigation, my
go
lord,
beyond that notice now.
My lord,
We go into the materials.
Yes, as part of my
And
lord,
again, page
Yes.
24, Lordship, arrest memo, before that, at least one attestation of witness, Lordship, is to be there, Lordship. As per DK Basu judgment, Lordship, and also the provision under section 36 of BNSS, Lordship,
You're right.
not there, Lordship.
You're right.
In support of that, Lordship, I have already provided the judgment of DK Basu case, Lordship.
You give the whole judgment. You can give if you want. The relevant parts maybe you can give.
Yes, Lord.
And see. Apparently, it does not have any. Sure, because- So, yes. Well, no. From the diary, you can submit, but it's the,
yes, but
because the
But the
apparent
degree-
on allegations are serious. Robbery at night, these are,
during
serious
investigation,
matters of public safety.
during investigation, my lord, this person was apprehended, my lord.
Hmm.
My lord, while apprehended him, my lord, the co-accused, my lord, those who is the main accused, my lord,
Hmm.
he fled away, my lord.
Hmm.
So, my lord, case diary does not reveal, my lord, whether the stolen article has been recovered or not, my lord. For that purpose, my lord, I require some time, my lord, to my lord, obtain some instruction, my lord, whether the stolen goods has been recovered or not. Because in his statement, my lord, the co-accused has stated, my lord,
Mhm.
they have purchased the stolen goods, my lord,
Hmm.
given by some another accused person, my lord. But it is not clear from the case
Investigation
that-
is only 15-20 days. But what about this notice? It should not have diary. Can it cross-check from the diary? It should have some signature, isn't it? Very difficult in serious matters if the police makes this kind of mistakes. Then it is not in the interest of society. Not in the interest of society.
In the statement, my lord, it is mentioned, my lord, whether the police officer is satisfied that the arrest is necessary, yes.
Hmm.
This is the my lord checklist, lord, so may kindly clear.
Hmm.
And regarding 48 notice also, the sent through WT message, which was not received by my father or parents, Lordship. And I have
The police,
This
the
is
thing,
the checklist prepared by the investigating officer, my lord, so may
Hmm.
kindly peruse, my lord.
no, regarding notice.
Notice, my lord, that is why notice has not been.
No, checklist is okay.
Yes.
Checklist is off. Checklist okay. Arrest memo should have some more documents. It does not have any signature. They should not make this kind of mistakes. These are serious matters otherwise. Alleged offenses are serious. Serious offenses. What do you wanted to say? 47 notice, page?
Page number. Page 20. Page 23, sent through WT message to OC Bogriwari PS.
WT message, if it is an Usually it's short, but if electronic message is no problem. If it is in detail and it has to be sent, you know, and it has to be received. See, the thing is that electronic message, it has been held na, in until or something. Yeah. The electronic message will not do. But it has to be, if it is sent electronically, and the concerned PS must take out a printout and take a signature. And if it is refused to be signed, because they may be, they can be vested interest on this side also. That if there is attempt to refuse the notice and take advantage of it, and then the like that address postal thing which you have in civil, the IO has to make an endorsement that attempt was made, but it was not successful.
Then, my lord, we have to
Yes.
call for the update case diary, my lord. But Lordship may kindly pay with page number 23, my lord. That is the 48 notice served to the accused person, my lord. My lord, down below, my lord. My lord, since he is from Bogoribari, my lord.
Yes, yes.
So send
For
through
execution
WT message
service.
to the OC Bogoribari PS for execution and serve, my lord.
Yes. This much the police will have to take the trouble. They have to take this trouble. Otherwise, you'll create a situation where this can be taken advantage of.
Lordship, and regarding
It's
arrest
not in the
of-
interest of
I
society.
have supported on order of this coordinate bench, Lordship. Already I have supported that order also, already given Lordship. In that, this Lordship on.
Stolen property is not recovered as per this FIR.
Here from the case diary. That is why, my lord, I pay for some time, my lord. So that, my lord, some instruction can be obtained, my lord, whether the stolen article has been recovered or not, my lord.
You take the instructions, but within this week, we'll have to dispose of.
Lordship, I am a
Today,
student,
Tuesday,
Lordship.
my lord, Friday I am paying.
No, don't.
I'm-
don't, sir. See, the
I'm-
allegations are serious. A student, maybe student or whatever it is.
Lordship, but I am not the main accused, Lordship, because the receiver, because I am working with the
No, these
receiver of
are,
the stolen property.
see,
Lordship.
they may be, these kind of things are not so simple.
Lordship,
They
violation
may,
to the-
they may be rackets, so
There is
when people buy certain kinds of property, sometimes they know that, if a bike is sold for 3,000 rupees, definitely, it is not likely to be, it is likely to be a stolen property.
Also, Lordship, I have taken also already on
So
on
just-
police custody. Lordship.
Just hold on, I would request you, just hold on for a few days. You fix it on Thursday.
Friday, my lord.
I'll give this and I'll return it to you. Since you have taken out a print, I'll give you,
Return the case diary.
no, I'll give you this. I'll give you back on the next day.
Interim bail may be granted.
No, no,
in the
no.
meantime, Lordship.
Dacoity at 2 p.m., 2 a.m. at night, robbery, alleged, It cannot be.
I
The,
have supported the order also, Lordship. In case of no more, Lordship.
the Learned Petitioner Council submits that the notice under section, the arrest memo furnished to the accused, the time of arrest does not bear the signature of any witnesses. Full stop. The investigation, the case diary has been received, but the learned prosecutor submits that it is not clear it is not clear therefrom as to whether the stolen property has been recovered. Stop that. You will send back the diary?
No, send me, my lord, only take the instruction. my lord.
Yeah, it will not come
Otherwise, it
otherwise.
may not come again.
Cycle will not be completed, actually. So the case diary be retained and prosecution shall take instructions regarding the recovery of stolen property.
Maybe fix tomorrow, Lordship.
No, Friday, my lord.
Humble prayer, Lordship.
Only
They have
take
their,
for 2 more days.
yeah, fixing is no use. Yeah, they also have their load. Fix it on 18th or 19th? 19th?
19 months.
52,
Obliged.
Yeah. Mr. Goyal.
439 application, date of arrest is 31/10, my lord,
Everything.
46 days behind the bar. My case diary was called for, my lord, short date was fixed, my lord.
Mhm. Bank employee.
This is with regard to the bank, my lord, Axis Bank.
And some agreement later on
Yes,
for returning them.
yes.
Anyway,
It will be last phase of the investigating officer, my lord. Note of the investigating officer.
diary has been,
Diary received, my lord. Last phase, my lord.
last phase. Let's see.
इसके ऊपर ही बैग लिख সিহঁতৰ বেয়া লাগিছে পইচা বিচাৰিছিল মোক বোলে
আগতে কিয় ক'ব লাগে?
মই আগতে কৈ আছো
আগতে কিয় ক'ব?
That's okay. No. She has supported this allegation.
So what I am on, my lord will kindly see. Now at page, my lord, FIR has been lodged. Now thereafter, my lord will kindly come to the documents, my lord, at page 16, my lord. The second para itself will speak in volume. That said, there was an unfortunate misunderstanding leading to myself filing of the complaint and my issues having resolved. I do not want to carry on the instant case and face any further charges on the affair so and so, and I therefore request to kind to self to withdraw the aforesaid complaint, and for this act of kindness I shall ever be grateful. Now my lord will again come to the next money receipt, my lord. And this money has been received back by her, the informant. Last line is very important. Henceforth, I shall have no claims whatsoever in this regard. Now, again, my lord, that agreement at page 18, my lord, will kindly
Yes.
come.
No, no, it has been reflected in the case diary.
Yes, my lord,
No issue.
one thing, my lord, page 19, my lord. Last time I have not been able to point out, my lord. Second paragraph, that I have given an amount of so and so to Alphas. It was a loan. House number so and so in the district of Kamrup Metro as loan. Am I clear? And so misunderstanding, so affair. 46 days behind the bar, my lord. Bye
It
bye.
would be not fair. By Mother Ruby by so and so, the State Bank of India. Alpha son of so and so.
And my lord, all that.
His mother returned.
Yes, yes, his mother also returned because it was been forwarded to the mother's account, my lord.
It is a part of the case.
Yes, and my lord, on the last occasion, was asking me for the original, my lord, at the time of.
Not really.
Anyway, it
I
is
said
with
that
me,
you
my
can
lord.
keep it. If necessary, we'll see it.
Yes, yes,
Of course, I trust him.
yes.
No, don't need it also. No issues. Just keep it. Third, the Bhuya, Council, and R.J. Burla, that additional people. The petitioner, Alfaz Ahmed Talukdar, is arrested on 31/10/2025. Is seeking bail in connection with Hatigaon PS case number so and so. The allegation in the FIR dated 29/10/2025 was that amount of rupees 5.5 lakhs went missing from the pension account of her husband, and the and it was alleged that the petitioner was an employee of the bank, had transferred the amount from her account to his mother's account. It is drawing attention to the relevant documents. Mr. Bhuya, the learned counsel, submits that in the meantime, the parties have arrived at a settlement whereby the informant has stated that she had given the amount of rupees 5.5 lakhs as loan to the accused petitioner, and that it has been now returned by his mother, Ruby Begum, full stop. The case diary has been received, and drawing attention to the relevant portion, the learned additional PP submits that the said agreement is also reflected in the case diary, and affidavit, no? Reflected in the case diary. I peruse the pointed out portions indicating that indicating the statement of the complainant about receiving the money and expressing her unwillingness to proceed with the case. Full stop. However, the petitioner has already spent 46 days in custody. In the circumstances, the petitioner is allowed to go on bail of rupees 15,000 with one surety of the like amount to the satisfaction of the concerned learned court, and subject to the condition that we shall cooperate with the process of law. Return case diary, bail petition stands disposed of.
Deeply obliged.
Bail hearing, item number 22.
May please allow. Now, in this case, the petitioners were granted interim bail. They appeared before the IO, recorded their statement. CD was called for. To my information, charge sheet has been filed in the case.
We have not any information regarding that.
Pendency of this bail petition, that's been filed. Allegation, page 10 is the FIR, Allegation has been low when Zakir Hussain alleging that his vehicle was intercepted by the petitioners and forcefully taken away ₹5,000 from him. The fact remains, the petitioner number 2, he has a vegetable shop, and the informant is a vendor, who supplies vegetable from Nagaon to different places of Aparasam. But before the incident, he failed to supply the vegetables to the petitioner number 2, and after taking money from the petitioner number 2, that resulted the altercation between the informant and the petitioner. Subsequently, this FI has been.
Yes. So that is, this investigation is complete?
Yes.
No, charge sheet is submitted.
To my information, I do not know.
It's not reflected in
It's
that,
not
because sometimes they write in the backside.
Yes, backside, but it is what, it was not written in that part of it.
Since my petitioner has recorded a statement before the IO,
Recorded a statement, where your statement is here.
there may not be any necessary for
Yes,
this.
the petitioner was granted interim bail on 10/7/2025.
Petitioners, three
Petitioners in connection with the instant PS case, that is Jorat PS case number 328 of 2025 under so and so section. Full stop. Pursuant to grant of interim, the petitioners appeared before the IO and their statements recorded, which is confirmed by the learned additional PP on the basis of the received case diary. Full stop. The learned counsel for the petitioner submits that as per his instruction, investigation is completed, resulting in a charge sheet. The case diary has been received. There is sufficient progress in the investigation, but no noting is there regarding filing of charge sheet. Nevertheless, in the circumstances, the interim bail is granted by the order dated so and so is hereby made absolute, subject to the condition that it shall cooperate with remaining investigation. It shall not hamper or temper evidence. Return back is there, the petition stands disposed of.
Obliged, Lord.
24, 25.
May I please, your lordship? Lordship, in item number 24 and 25, the petitioner is same. He is already on bail, interim bail, and he has already appeared and his statement were recorded. In item number 24, the basic allegation is that in 24, that when the police person came to my place, I deterred them from discharging their lawful duties. Basically what has happened, the case number for 25 arises of 25 arises 24 regarding some dispute regarding some land dispute. Actually, in the GD entry was in the item number 25, there was a GD entry first, and lordship will find the FIR at page number 15. It is specifically mentioned that on the basis of a GD entry, they came to my place in my house, and accordingly they pick up my father and my brother also, younger brother, and my younger brother was given bail after 1 month by this honorable court. Regarding some rent amount, this issue has arisen along with my father, and the main informant of the GD entry was one Jainul Haq. Regarding, he was my tenant, and for last 5 months he has not paid the rent. So I said him that I've actually scolded him with some words that if you are unable to clear my rent, then you have to leave my shop. And accordingly, on that basis, he has filed a GD entry, which is the second case, 25. Item number 25 is the GD entry. And on the basis of GD entry, on that day, police personnel along with the complainant came to my place of my house for inquiring the matter.
So thereafter this case
Yes,
arose.
and if your lordship reads the FIR, the allegation is that there was some pushing and shoving.
Hmm.
And in the manner, because they have already picked my father
Hmm.
and my
Yes, yes.
younger brother also, so I shoved them injurious, something has happened that, but regarding that, there is no mention.
Hmm.
There
There-
were 5 police person in total. How can I attempt to kill or something? So-
This is a separate PS case, right? That is
Yes,
different.
yes, both are separate
It is
PS.
2428, it's from Nilam Bazar PS 133.
Yes, yes, Nelam Bazar, absolutely.
Later
That's
on,
different.
GD13 was
No.
registered into a
This is
case.
Nelam Bazar 133 I'm taking. up.
Yes, yes.
that's
The
the-
first case
yes,
is
sir, there is a
133.
CD lot.
They have appeared?
They have appeared and statement recorded, only thing is they are, that thing is clear.
This we can make an absolute. You Chaudhary, learned counsel for the petitioner, and DP Goswami additional PP, huh? You Chaudhary and DP Goswami. 9/10/2025 order to first two para 1 and 2 you can take same. Yeah, let's stop. The case diary has been received
Yeah.
and the learned additional PP confirms that pursuant to grant of interim, the petitioners have appeared, the petitioner has appeared before the IO and his statement recorded. Full stop. There's also stated to be some progress in the investigation. Full stop. The given facts and circumstances, the interim bail is not required to be cancelled and should be confirmed in my considered view. Thus, the interim bail dated so and so is hereby made absolute, subject to the condition that it will cooperate with remaining investigation and shall not hamper or temporary defense. This is done. And
Actually, the second case similar, this is on the basis of GD entry. And later on, the GD entry was registered
into
into the
a re-
case. Yes, that the case number is Nilam Bazar 142 2025.
That we have not received yet.
Aji case diary aana hai?
Even now. That case they not.
here also interim is there. No?
Yes,
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 same
they are also interim, same similar facts, lordship, only on that. This is the GD entry. On the
GD.
basis of this, the later on the case was registered.
Registered. This is PS case number
142 2025.
142. Mentioned here actually. When you filed it, there was no PS case, right?
There was only a GD entry on the basis
The
on
petitioner
apprehension we came.
preferred this pre-arrest bill application with regard to a complaint made by the informant stated to be his tenant,
That's it.
pursuant to which Nilam Bazar PSGD number 20 of 2000 dated
23/9,
number 20
2025.
dated 23/9/2025 was made. Full stop. The petitioner was granted, so it is submitted that subsequently Nilam Bazar PS case number 142
Right, no?
2025 was registered. The petitioner was granted interim protection on 15/10/2025. Case diary call for is not yet received. Issue fresh reminder. The interim bail stands extended till the next date of listing. List on. After reopening, first week, 7 months.
26.
See, but in the GD entry case, lordship,
Yes.
otherwise the sections are bailable sections. I have seen
Bailable
it,
sections?
yes,
It's
because
not
the
necessary.
sections are
No, no, it will.
1, 2B,
Then AB will not be necessary.
yes,
There is this rulings also there.
yes.
It's not
Regarding item number 25,
25.
Nijambara GD entry case number, which is subsequently 61 2B, lordship, that is criminal conspiracy. If the conspiracy is not serious nature, in 6 months, that will be bailable, and thereafter, lordship, 329(4), criminal trespass, punishment is 3 months.
So any case, should we look at some section might have been added also, we do not
Lordship,
know.
then
So we can see interim is there, no issues.
lordship,
Resolve it. Otherwise, it's not, it won't be maintained.
apply there.
Okay, do it again. Okay, same order.
It is for your interim, we have not received the case diary.
Kalyani Roy.
My lord, in this case, after getting interim, my lord, I appeared before the IO, my lord, and my abstention has been recorded, my lord.
She was,
Allegation, my lord, of not paying the installments, my lord, after selling the vehicle, my lord. So then the civil dispute, my lord, there is an existing agreement between the informant and the accused, my lord.
the petitioner was granted interim bail on 16/10/2025, pursuant to which he is stated to have appeared before the Iowa statement recorded. Full stop. The same is confirmed by the learned additional PP. CD is not received. No, sorry, you cannot say that. We cannot say that. The same. However, it is submitted that case diary is not received. However, the learned additional PP submits that the case diary is not received. Issue reminder. Interim bail stands extended till the next date of listing. Fixed on 7/1,
8/1/26.
8/1/26.
27.
27 of petitioner is an interim. We are up to date. CD was called for, but we have received a case but not up to date. It was last up to date on
We can dispose it off. Let us dispose it off.
1925.
9.
It was
Maybe
updated
little
on
lordship, kindly give him timing, my lord. Timing.
Time. Just a minute. It may not be necessary also because we may. Okay, after some time.
Oh, let's.
Well, it is updated till which date?
19.
9/10.
1925.
It will. About 2%. It will.
Interim was granted on
Yes.
1710.
26%, right?
Twenty-eight.
Please, your lordship. CD and medical report was called for, your lordship, earlier. There, both the parties are cousin brothers. There is a dispute regarding the correction of land record, your lordship. Land record document.
My lord, in this case, my lord, medical report is yet to receive, my lord. That will be, in fact, my lord, if necessary, my lord.
Several dates already gone, your lordship. First on 17/10, thereafter 31st October, 13 November, 8th December.
Otherwise, there are.
Diary has,
sufficient
huh?
Diaries available
Come.
with us, my lord.
Materials are
Otherwise,
there.
there are sufficient materials against.
But
this person.
medical report has to be cross-checked.
Yes, my lord, cross-check.
I pray for some protection, your lordship.
Because there are some
Long
materials.
pending case, your lordship, all are family member, your
How
lordship.
can I give most of this?
There is a
Lot of materials.
In lodging the FIR, your lordship, the injury is serious, then there is a delay of 5 days, your lordship, without any reasonable
the
cause,
allegation?
your lordship.
What is the allegation?
Allegation, there is a
Marpit.
market between the parties on a village mail, your lordship, at a village mail. Both are adjacent house, your lordship.
Serious
beside it.
injuries. No, sorry. Anyway, medical report is necessary. The case diary has been received. And it is submitted by the prosecutor, learned additional PP that investigation has revealed sufficient incriminating materials against the petitioners. But that perusal of the medical report is also necessary, which is not available at this stage.
19.
Full stop. Medical report, when can you get it? Retaining the case diary?
My lord. We'll fix it immediately after vacation, my lord, on 9th, my lord.
Vacation is a very long, you know, so on 5th. Mainly on 19, your lordship, license.
So 19, my lord, we cannot send the case diary and call it.
Right,
That
yes.
will not come.
It is not possible, my lord.
That will not come.
You can fix a date, my lord, but it will not serve, my lord.
In that case, you'll have to keep the case diary and call for medical report.
Then we can try, my lord.
The case diary may be retained and medical report may be requisitioned for the next date. Full stop. List on 19.
29.
Fix more cases on 18 rather than 19th. You know, that will be more manageable.
So
Yes.
may kindly fixed it, this case on 6, 7 or lordship, 5, 6, 6 or 7.
This new case, earlier case.
Lordship, yes, lordship.
So
28,
just come on
18.
9th, my lord, 9th.
Ninth is in.
So you,
Fifth or sixth, your lordship.
after vacation is okay for you? After
Immediate
vacation,
after vacation.
as you wish.
The ninth is here.
Then in that case, will you send back the case
Yes,
diary?
I will send that.
Not change the dictation, no? Cut it out. Case diary shall be returned back and procured again with updated investigation and the medical report. Full stop. List on
1
9-1.
May short.
9-1.
No, you're saying after vacation.
After vacation,
yeah, let's-
five or six.
6.
7 man.
6. 7.
Obliged.
So which one?
obliged.
We are
7.
taking
7.
2-3 days so that.
Yes, yes.
Already 4-5
And
days
you have
already
the
back
chart
from
actually.
vacation.
I also have, but still.
29.
Yes.
In this case, my lord, there are the 3 number accused person, my lord, petitioner. Out of 3 number petitioner, my lord, 2 person already granted interim protection, my lord. Petition number 2 and 3, my lord. Petition number 2 is the wife of the petition number 1, and petition number 3 is the daughter of the petition number 1. My lord, this is a family dispute matter, my lord. Now, this is a was fall, which material is talking about.
Diary is received.
Yes, there is.
FIR page, the page number under 11, my lord, annex number 1.
Yes.
My lord, this is a fully family dispute matter, my lord. Regarding the altercation, my lord, altercation the house or bonding, my lord. They are the own relative, my lord. Informant is the victim is the brother of the, my lord, petition number 1, my lord.
So anyway, tell me. Additional brief.
Madam, they have received the case diary, madam. The other 2 persons, madam, who was granted interim, madam, they have appeared a statement recorded, madam.
There's no direct allegation against
Yes,
them.
madam. Now, madam, as per the madam, medical injury report, madam. Madam, this is the report, madam. Although it is mentioned that, madam, it is severe, madam, but it was caused by what sharp open or blunt open, nothing has been mentioned, madam. So, Lordship may kindly peruse this report, madam.
And otherwise, other materials?
The matter, madam, the victim is implicated, madam.
164 or police statement.
Statement, madam, under 161.
Brother-in-law is also stated to be injured. Amjad,
Yes, madam,
his
that is
statement is
Amjad
there.
Mia.
is also there, madam.
Also there.
Yes, the injury report is not in the format, my lord, where
Left
it is
wrist
stated
deep
that, my lord,
perforation,
previous caused by
tibia structures.
sharp weapon or not, madam.
Yeah, this is a serious injury only because the nerves have been cut totally. Yes, and the fracture of the bones also. This was the grievous injury. Why they have not should they have written? It was surgically repaired.
Petition number 2 and 3, my lord, female person, my lord. They are the
Yeah.
wife and the daughter.
No,
of the
there's no much. There's no allegation against them also.
Against them, not much, madam, but the only allegation against them is Alok Mia, madam.
Yes, yes. The
Alok,
allegation is.
Alok, petition number 1.
Mm.
Petition number 1, my lord, Alok Mia, and my lord, victim, my lord, Amjad Mia.
Mm.
They are by their own brother, my lord.
Mm.
Inside the home, my lord. Same boundary, my lord, inside the. Yes.
We first heard Mr. Rahman and RJ Bora. second paragraph, 10, 11, 25 or second paragraph to no need to repeat. First. Allegation in the FIR, in a FIR dated so and so, dated 7/8/2025. Is that the accused persons trespassed into her house and accused person assaulted her husband, causing grievous injuries on the right hand. And when her brother-in-law tried to intervene, he was also assaulted, causing grievous injuries on the finger. On 10/11/25, petitioner number 2 and 3, being the wife and daughter of the petitioner number 1, were granted interim bail with the observation that no direct role was attributed to them. Full stop. Pursuant thereof, it is confirmed by the learned additional PP that they have appeared and their statements have been recorded. Full stop. The learned petitioner counsel submits that it is it was a dispute within the family. Full stop. The case diary is placed before me. The medical report of the victim indicates medical report of Monjil Mia indicates serious injuries on the wrist with severing of structures, nerves and arteries, and fracture of carpal bone, and the injuries had to be surgically intervened. Full stop. So it is submitted by the learned additional PP that in their statement, the victims have implicated the petitioner number 1. In the given facts and circumstances, the interim bail granted to petitioner number 2 and 3 is hereby made absolute, subject to the condition that they shall cooperate with the remaining investigation and shall not hamper and tamper evidence. Full stop. However, with regard to petitioner number 1, the prayer for prayers bill stands rejected at this stage. Full stop. Return back the case diary. Okay. After lunch, we'll resume. Your lunch. Listখন থাকি গ'ল নেকি তাতে? Listen. Cause list. Yeah. Item. Just a minute. Yes. Straight.
Time being item 14.
27 or 14?
14, 27 because
Yes.
It's similar order, Your Lordship.
So, yes. It was kept for what, Mr. Burra?
To verify, my lord, whether the ground of arrest, my lord,
Oh,
which has been furnished, my lord.
Ground of
Lord,
arrest.
in this regard, my lord, I beg to, my lord, point out, my lord, the first order, my lord, that is in the scan copy of the very first
First
page,
order?
my lord.
Yes, yes.
Can you peruse the order, my lord, of the trial court wherein it was first produced, my lord?
That is there.
Yes. Now, my lord, this ground, non-furnishing of the ground of arrest, my lord, what is mentioned in the, my lord, in the judgment of the forbid two cases, then Vihan Kumar, my lord, and Pankaj Bansal, my lord. It is that, my lord, whether that has been communicated to him or not, my lord.
In this
and
case, the contention is regarding non-compliance with section 47
47, my lord. Yes.
or 48.
No, 47, my lord. That is what my learned friend has submitted, my
47.
lord. Now, my lord, on bare prejudice of this order, my lord,
Mhm.
it is, my lord, it shows, my lord, that ground of arrest, he is well aware about the ground of arrest, my lord.
It's true.
And immediately, my lord, on the day of production itself, my lord,
Uh-huh.
one legal aid counsel was, my lord,
Given
engaged,
to
my
him.
lord, to represent him, my lord. Now, my lord, where
For
is the
that day,
question? Yes, where is the question of, my lord, the violation of the natural justice, my lord? Now, in my lord, state of Karnataka versus Darshan, my
his
lord.
family will engage a counsel.
No,
But for that day, one legal aid counsel was given.
In that day itself, on that day
They-
itself, my lord, legal
he
aid
said-
counsel was, my lord,
Appointed,
engaged, my
no,
lord,
but
to represent him.
and he also said that his family will engage.
Yes, my
That
lord.
his family has come to know.
Yes, my lord.
But anyway, what was the note? Was the notice? Have you annexed the notice? Or you said that it was not given to you? No, have you? I forgot an
It is,
actually.
no, it is, my lord, furnished, my lord. His contention was that, my lord.
It is
ground
not
of arrest
complete.
was
Not
furnished, my lord,
complete.
But not complete.
my lord, not as per the, my lord, requirement, my lord. Because
could-
detailed ground of arrest has to be furnished, my lord. as
Could
per
we
the-
find grounds of
Yes, it is there, my lord.
notice is there?
Ground of arrest is there, my lord.
Achha.
But it is only mentioned that you have been arrested, you are arrested in connection with this. So
Case number is there, your lordship, but
it
grant
is
of
not available in, my lord.
Arrest
Let me see that first.
Non available in nature, my lord.
on green flag.
Was that one? That's a short. Any other stuff?
My lord, violation of fundamental right will come, my lord.
No,
When
no,
he is
no,
not
no,
aware
actually
about
the-
his arrest, my lord.
No. The thing is that this grounds of arrest, we cannot only go. It is true that if a court observe, if another court, which is junior in hierarchy to this court makes an observation that the compliance has been made, we also have to we can rely on that, but not 100%, because we have to cross check also, because that court can be in error also sometimes. Suppose prima facie this will only this much will not be sufficient, we know that.
In my lord, the state of Karnataka versus Johnson, my lord. It is said, my lord, the violation of fundamental right will, question of violation of fundamental right will come, my lord, when he is not aware about his arrest, my lord. And when he has not been able to engage any counsel, my lord, while he was produced before the production court, my lord. In this case, my lord, the person was caught red-handed, my lord, along with a commercial quantity of contraband, my lord. Secondly, my lord, while he was produced, my lord, it is very much clear from the order, my lord.
When was he arrested?
Arrested on
29/7, my lord. That is the first, as per the first order, my lord.
29/7/24. Total custody 1 year, 4 months and 17 days.
29/7/25.
24.
Achha.
24.
No, you have written 25.
20 was wrongly written. She actually 24. Forwarding report. Lordship, 24. It's a
Must be.
typing mistake.
Yeah.
There is number 12, your lordship.
Typing mistake. Yes.
And even, my lord, if this 47 and 48 is not complied with, then even the, my lord, the production court as well as the trial court also can grant bail, my lord.
That's true. But if the learned court below has said that this is sufficient, this is not correct. No, because that's why I said, is there any other component?
At this stage, my lord, he is
We
not,
do not know.
my lord, he is not on merit, my lord, because the
It's
merit,
not
my
on
lord,
this. It's not.
it is a
it's not
certificate case, my lord.
Apart from this, because this is blank. That's why I asked.
Yes, my lord.
Actually, this is the component or is some other component?
That is we have received only the scan copy. And then lordship may call for a detailed ground of arrest, my lord, what? Because that has been sent through scan, my lord.
Is available, your lordship. There is a format of notice, but ground of arrest or reason of arrest, whatever may be, but not mentioned anywhere.
My humble submission is that, my lord, he has to show is the prejudice, my lord, due to non-furnishing of his
Prejudice
ground of arrest,
test,
my-
well, that is prejudice test is still evolving actually, not fully settled prejudice test. Darshan says prejudice test, that's true.
He has to show
But
prejudice.
it is
What-
still settled.
What prejudice has been caused to him, my
And
lord?
I have
For
produced
what
those-
that, my lord, he could not engage any counsel, my lord.
Well, I
He is
agree.
not aware about the ground of arrest or the reason
No, I
of
think,
arrest, my lord.
I have
That
produced
prejudice he has to show, my lord.
two similar order, your lordship. Both the orders discussed about
The
the.
heard Mr. So-and-so, learned counsel, and R.J. Bora learned. The petitioner invoking 483 BNSS seeking regular bail in connection with Thikajuli PS case number 133 of 24 under section so and so of the NDPS Act. The allegation in the FIR is about a recovery of about 24.5 kgs of suspected ganja from the accused person. He was on 28/7/2024. Full stop. On which day the FIR was also lodged. Full stop. The accused was arrested on 29/7/2024 and since then he's in custody. Since the penal provisions pertaining to commercial quantity, alleged commercial quantity of ganja has been given, therefore, the applicant, you can have a seat. I'll record your submissions. Therefore, the applicability of the rigors of section 37 of the NDPS Act has to be seen. Full stop. So the Learned Counsel has also raised the contention of non-compliance with the procedural requirement pertaining to the notice under section 47 BNSS. It is submitted that the notice, the compliance, there's no compliance with the state, the compliance with the stipulations pertaining to the said notice. Apart from the aspect of length of detention, the case resulted in a charge sheet and presently at the stage of trial.
Two prosecutors have been examined.
Two prosecution.
Yes, and they have implicated him.
That's a fully.
At the case is at the stage of trial pursuant to framing of charge, and the two prosecution witnesses are stated to have been examined out of 8 witnesses. 8 witnesses.
8 witnesses.
Not much. 8 witnesses. Full stop. On the other hand, the learned additional public prosecutor, after referring to the relevant portions of the case diary, draws my attention to an order dated so and so. The order dated 29/7/24 passed by the learned JMFC at the time of production of the accused petitioner. It is stated therein that there has been due compliance with section 47, with compliance with it is stated therein that the accused has been arrested in compliance with the provisions of law. Italics. It is also stated therein that the accused submitted before the said learned court that his family would engage a counsel, but on that day a legal aid counsel was appointed first. In this backdrop, the learned additional PP, taking his argument forward, submits that it cannot be said that the petitioner suffered any prejudice, as he could make his defense before the court to a learned counsel, and his family was also preparing to engage the counsel. It is contended that therefore the petitioner cannot take the ground of non-compliance with the mandatory notices. I have perused the relevant materials and given my consideration to the matter. Before delving into the merits, the contention regarding notice at the time of arrest has to be seen. For this purpose, the notice under section 47 BNSS furnished to the accused at the time of his arrest, and which is For this purpose, the notice under 47 VNSS available in the scan record is reproduced herein below. All are blank this side. Oh, they have one-sided, they have done this. No, no, it's okay. It's not blank. They've done one-sided printing. That's okay, then it's okay. I do reproduce code, like that. Oh, this one. I want to record. What is? Meta mark for this one. Yes. Reproduce. Full stop. In terms of the principles laid down by the Honorable Supreme Court in the case of Purkashta and Rehan Kumar, the aforesaid nature of the notice under 47 would not be sufficient to meet the constitutional standards under Article 22(1) of the Constitution. Full stop. In my considered opinion, the decision in Purkashta and Rehan Kumar has not really said and that such compliance would be subject to the test of prejudice, and the said position in terms of the principles laid down in these two decisions still hold a field. In the case of state of Karnataka versus Darshan, slightly different, somewhat different viewpoint seems to have been taken. However, the decisions are of equal quorum. Next, coming back to the facts of the instant case. As the aforesaid notice would not meet the constitutional standards in terms of the law laid down by the Supreme Court, as has already been mentioned above, I come to the considered opinion that despite the serious nature of the alleged offences, this court is required to grant bail to the accused at this stage. Full stop. In any case, he has been in arbitrary detention for more than a year. Consequently, in the given facts and circumstances, 75,000, a little higher, huh? 75,000 with one surety of the like amount to the satisfaction of the concerned learned court, and subject to the following conditions. Number one, he shall be available for the remaining trial or cooperate with remaining trial. He shall not hamper or tamper evidence, not try to influence witnesses. He shall not indulge in any illegal activities, including any activities violative of the NDPS Act.
Before the learned special judge,
Let there be two sureties, madam.
Sureties. Usually I give one only. Yes, can be also. He's from where? Local person?
He's from Assam only.
One. So 1 lakh. One.
before special judge, Sonitpur, Tessur.
1 lakh. 1 lakh. He can.
Yes,
No.
yes.
See, most cases abscondence is not much of a problem I've seen, because nowadays everybody's database is there, no? Like after Aadhaar and all this is there. Influencing witnesses is a bigger concern.
My lord, that they will be convicted, my lord, then they will stop, my lord, appearing before a trial.
No, then
That is the difficulty, my lord. I have sent many scans to him, my
no,
lord.
no, then
After examining, my lord, few witnesses, my lord, they have stopped.
I don't know. Maybe somehow the experiences differ, because it may be different in different districts. But I have seen some cases they expect. Most cases, abscondence is not a bigger issue. Is the influencing of witnesses. especially non-official witnesses. This is the law. What can you do? This is the law. Serious offenses. At that time, it was not there. 24, it was not there. Police was not aware. 24 July, police was not. It was the format. This was the format. So in a way, nobody's fault. Yes, next.
Petitioner was granted interim bail by order of the 17/10/2025, and as per my instruction, Lordship, he has appeared and his statement was recorded.
PD is not up to date, okay? The updation is
Lordship, absolute Lordship. And
1925.
Two occasions also, Lordship, it could not come with updated.
What can you do? What is the allegation? This party. Struck with assaultment of murder, assaulting police party. Anyway,
Granted by bail by the court.
the same order. It's CD has come.
Yes. Up to the city is not, but his statement is not effective.
Is it possible to dispose it of on the basis of the existing CD? Or because the allegations are not so light, isn't it?
Assaulting the police person.
Not so light.
Lordship, as my humble submission, Lordship, he appeared and his statement was recorded.
That's okay.
His property.
That's I appreciate.
One of them, he's one of them.
Must have been some reason why interim was granted, right? The observation was no progress in it. Yes, I've given the reasons actually why this is. Medical report is there. I have narrated actually why interim was given.
Yes, Lordship, medical report only just his swelling.
No, that is an observation of
Yes,
the
yes, that
session
are-
judge.
yes,
Must have been on basis of medical report only.
Yes.
Otherwise, cannot say.
Yes.
That's why I said it should be
Yes.
available in the case diary.
Yes,
Let's see.
absolutely.
Let me see if I can dispose it of, otherwise.
Yes, okay. Physical. Mesa is not reflected here, what physical assault by public on. The specific medical report is not here, where you know, what type of weapons you used and injury was there. The only thing is. that
Injuries are described.
Injuries are not described, chest pain, tenderness. Abdomen, tenderness, swelling in tenderness on multiple.
Same
side
thing
of
is reflected by the
Yes,
session.
Swelling was there, Lordship, and
Should I dispose it of then?
then
Instead of we get so many cases,
Lots
so let us, let's not spend too much time on matter. Mr. Is it Ahmed? I say 1710 order to available, huh? The first paragraph is same. And the allegation in the FIR is that members of the crowd tried to attack the informant who is a police person, right? Informant, and assaulted him and deterred the police party from discharging government duty. Full stop. That's what para 4-31 of the earlier order. The petitioners, how many petitioners are there? Petitioners or petitioner? One. He was granted interim bail on 17/10/2025. And pursuant to which he stated to have appeared in any statement recorded, full stop. His statement is available? No.
no.
Statement is not available. However, the case diary is received, but the statement of the accused petitioner is not available in the case diary. the the medical report, it is submitted by the medical upon the submissions of the learned additional PP with regard to the medical report. I find that the same correlates with the observations of the learned session judge as indicated above. The given facts and circumstances, I'm inclined to dispose of the bail petition. And the interim bail is granted by 1710 is hereby made absolute, subject to the condition that they shall cooperate with the remaining investigation. They shall not try to harm, harass, or influence witnesses, shall not hamper or temporary arrest. They shall not misuse their liberty to commit any offense or illegal activities. Return back the case there.
Item number 30.
Yeah, Your Lordship, in this case, petitioner is an interim lordship and he appeared before the IO lordship. On the last occasion, lordship uploaded, it says he was controller. Last occasion, CD was the lordship, but his statement was not there. Yeah. Yeah, pure-
Fraudulent vehicle sale, very one. Azizur Rahman.
He knows the FIR name person and therefore. I think. Today, ma'am.
Up-to-date নাই. So CD is received without up-to-date CD is required. Kind of. Definitely. Definitely the petitioner is not available in the case diary.
Okay, send it back. The case diary is received but stated to be not updated. It's return it back, and it may be and shall be procured again, along with updated investigation, including the statement of the petitioner. The interim bail passed, granted by order dated 28/10 shall continue till the next date of listing. List on 7/1/2026.
31.
Please, your lordship. Lordship, up to date CD not received, lordship. We have appeared before the IO on
You have appeared?
2/12.
No.
Did you receive, my lord? My lord, here, my lord, is a case, my lord. Where, my lord, that is a allegation is against one of my lord doctor, who is not a my lord doctor by profession. And he is, my lord, running his own clinic, my lord. And based on a, my lord, that is a one of the, my lord, that is a government, my lord, anti-quackery and vigilance officer who lodged an FIR, my lord. Now, the accused petitioner before your lordship is not the FIR name one, my lord. But who is that person, my lord? He is the, my lord, the person who produced all these people. Producer of all these, my lord, that is the fake doctors. He is the person of that agency, my lord.
Very well.
That is a
Allegation.
my lord. And my lord, it is in the initial stage. My lord may kindly go through the, my lord, only the yellow flag markings are there, my lord. At that stage, my lord.
Producer of fake doctors means these are agents.
One institution, my lord. When he was, my lord, that is, my lord.
I'll come to you.
Yes, my lord. My lord, may kindly peruse the, my lord, there is a statement of the accused person. Who is the FIR name accused, my lord? Dr. U.S. Sinha, my lord. So now, my lord, he got that, my lord, there is one certificate, my lord, from this, my lord, one organization, my lord. That is in the, my lord, FIR, my lord. And this person from whom, my lord, he got that certificate, my lord. He was the registrar of that organization, my lord, who is providing. Now his statement recorded, he said that in 2023, the organization becomes closed, my lord.
Mm.
And my lord, according to him, that I am providing the that is the my lord, there is the certificates and all. That's true, but that is for your these alternate medicines, not for all these things. Now, my lord, he even my lord, submitted one document, my lord,
Mm.
where my lord he wrote to some authority that it will be closed. That is, my lord, I have flag marked that letter also, my lord.
See,
Along with that, my lord, he write his name as a doctor. No doubt he has some other qualifications also, my lord. Now, my lord, it is not a case that one person is, my lord, arrested, my lord. One person is arrested. Many, my lord, people are there who are coming from these, not only these organizations, my lord, many other organizations. So, my lord, that is it is in very nascent stage, my lord. The police, my lord, file one, my lord, that is the bail objection prayer also, along with this. So, at this stage, my lord, if my lord anticipatory bail will be granted to the minor accused petitioner, it will affect the entire investigation. And the persons who get all such type of degrees, my lord, and my lord, those who are rendering their service to the common people as a my lord, that is a my lord, is a doctor, my lord. Your people's orientation is that he is a doctor and he is providing all type of prescription and all, my lord. For that reason, my lord, his custodial interrogation is required, and to find out all the my lord things, my lord. My lord, may kindly peruse his statement also, my lord. His statement is also recorded, my lord. My lord, some green flag marks are there. My lord, relevant parts I have flag marked, my lord. All green flag marks, my lord.
anyway, I'll come to your submission.
Lordship,
Yes, please.
let my senior heard lordship.
Mm.
Tomorrow.
Yeah. I consider you fully capable, but I will not force you also because I know there's some compulsions. You are fully capable, but you want me to keep it for tomorrow.
Tomorrow lordship, let me senior heard lordship.
There's a certificate of Harvard Medical School also. How come? Harvard Medical School, Department of Continuing Education. Notified that. Do they?
One is, my lord, there is a
They may be issuing some. They have some certificate programs also all over the world. People enroll, but
he is not, my lord, academic use, my lord. He is not the academic
Yes,
use, but he is the person, my lord, from whom, my lord, these people are getting, my lord, all these certificates and all. And now these people are practicing, my lord. It is not a one case, my lord.
okay, keep it for tomorrow.
Yes, my lord. Tomorrow.
Interim was given. Interim.
Interim is there, my lord.
Mm.
After that, my lord, he appeared, my lord, his statement
That is true.
was recorded.
Mm. The case diary has been received, but the council, your good name, please. Jay Ghosh. 6, another date. Praise for fixing the matter tomorrow, so that the leading counsel, Mr. P.K. Roy Chaudhary, can argue. Prayer is allowed. The case diary be retained. Interim shall continue till the next date of listing. Fix tomorrow. That did it. 17.
In this matter, my lord, CD not received, my lord. Item 32, my lord. So we pray for a my lord for
No interim.
For the 19th this week. Lordship, the CD has been awaited since 7/11, your lordship. On the last occasion also, lordship had noted the IOB directed to send the CD and the medical report expeditiously.
Is yes, yeah, it is true. Case diary is again not received today. Full stop. Issue reminder: the prosecution procured a case diary. Okay, right, like
Minor.
the next day, 19 or 18. 19. Last date is better. Second last day is better. I'm
Yes,
telling
ma'am.
you.
Yes, ma'am.
Second last day is better.
Senior has some difficulty.
19. So far, we have not fixed too many matters. Look here. Chart khonle bhalo. A chart khonle. Tomorrow we'll have the chart.
34.
19, my lord. This 19. Increase your lordship. Your lordship will find a FIR from page 11 to 16. Page 11 is the translated copy, your lordship. Allegation under section 118(1)(1091) and 189(1)(d). Lordship has called for the trial court records. Your lordship, due to some land dispute, your lordship, a fight evolved between two parties, your lordship. Thereafter, this FIR has been lost.
It is undergoing trial?
Trial, Lordship.
Yes,
Started.
Satisfaction file.
Evidence is started.
No,
Your lordship. It's in
Cognizance taken on 1/12/25. The charge sheet on 10/10/25.
Earlier, your lordship has granted bail to one of the accused number 6, your lordship, in this case.
Only for the considering of age, I think.
Mm-hmm.
He was
77.
old. He was
77 years
old.
old.
He was
that's fine.
older than the other accused. That's one.
The medical report is not legible.
Medical report as per Lordship, one injury report, Abdul Sattar Lordship, grievous by dangerous laceration with underlying skull and fracture 7x2x1 centimeter cube. And neck bar Ali, simple, nature of weapon cannot be exactly ascertained. Laceration 1x1x0.5 centimeter cube. And one Abdul Razak is also simple. But one person is grievous injury.
One person have sustained grievous injuries, others are simple.
Simple.
But grievous
Multiple
injuries,
are there, multiple injuries are there.
that's true. They were shown as absconders or what in the charge sheet?
Yes, Lordship.
Huh?
He was so.
No.
এটা কোন এই কথা
I, Hussein, learned counsel for the petitioner, and DP Goswami learned additional PP for the state. Full stop. Helamara PS case number, it will be order 13/11/2025. Full stop.
And the eyewitnesses are there also. In the case the Lordship, eyewitnesses also there.
Hmm. The allegation, the gist of the allegations in the FIR dated, what is the date of the FIR? Blank. 5/7/2025. It's about causing of injuries by the accused persons with sticks, iron rods, spade, etc. Full stop. Causing injuries. Full stop. The case is, upon investigation, the case resulted in a charge sheet, and the case is, trial is, evidence, prosecution evidence is not.
No, not yet. Formula that we
Okay.
taken.
The case is at the stage of appearance. Appearance. And poised for commencement of trial. Oh. Oh. No.
And the next date is Lordship 2/2/26
2/2/26.
for appearance.
The petitioners have been indicated as absconder in the charge sheet. Absconder,
Not everyone, your lordship. I have not seen the,
I'll leave it then, I'll not say. The learned additional PP on the basis of the received scanned case record submits that with regard to one of the victim, the injuries are grievous in nature, involving involving dangerous weapons and including head injury, and was referred to the neurosurgery of GMCH for further management. The other injuries are stated to be simple. The injuries of the other victims are stated to be simple. Full stop. In view of completion of investigation and the case being poised for commencement of trial, dash. Not much purpose would be served by detaining the accused at this stage. Accordingly, it is directed that in the event of their arrest in connection with this case, they may be allowed to go on bail of rupees 25,000 each. Surety of like amount. They will be available for the trial Number two, shall not hamper or temper dividends, shall maintain peace and not commit any illegal activities or offences. Full stop. Violation will take the bill. It will anticipatory bill in the event of arrest.
Because they are the neighbors,
Neighbors,
long distance.
dispute, this. They should not start fighting again. Then there'll be another case.
36.
May I please comment? According to my lord, they have appeared before the IO, my lord, and cooperated with the investigation, my lord. FIR is at case, my lord.
They have appeared in statement recorded, lordship. So, no, there is some business rivalry as well. They are doing some business partners.
Business rivalry and they are known persons.
Known persons. So
Friends. So they should have, we should not block their friendship. But people should not, I don't know why people take law into their hands. Tolerance, controlling anger is a very big challenge, like, no doubt. But still, it's necessary. We all have. Take it effortly has. 1, 2, 3, 4. Right here. 1 to 4 paragraphs in. The petitioner was granted, one petitioner, 2 petitioners were granted. The petitioners were granted interim bail on 24/11/2025. Pursuant to which they are stated to have appeared before the IO and statement recorded. The case diary has been received. The statements have been recorded. And it appears that the dispute arose out of some business relations between the 2 petitioners. Full stop. I see no reason to cancel the interim bail. Stop. Accordingly, the same is hereby made absolute, subject to the condition that they shall cooperate with the process of law. Full stop.
I'm obliged.
Return back case diary.
37.
this was an interim, lordship. We have not received a case diary.
Receive the case diary.
Is an interim.
Lordship.
Yes.
We put an informant, your lordship. In this matter, we tried to vacate the interim granted to the petitioners because as soon as they got interim, your lordship, they has been pressurizing us in many ways, threatening us. Along with that, it would have been reflected in the CD, your lordship, but however, the CD is not here. The fact is that another section has also been added in the matter. The CD may be called for.
Do you know which section?
Under what provision he is appearing? And how he is filing this, whether a leave has been granted by this court?
He has entered, you file a wakalat nama?
No, my lordship, kindly see.
Many
Being an informant, my lord.
Yes.
Now, unless and until leave is granted by this honorable court, my lord, how he can file an objection petition?
He has filed.
Yes,
Have you
he's
filed
filed.
objection?
Well, whether the leave?
No,
My lord, this is, we are in the court of law, my lord.
That's true, but where is the statutory provision that leave is necessary for the
My
informant
lord,
to appear?
my lord, your lordship, kindly see, why? Because
Let us see the stand, because they have to work under the instruction of the public prosecution.
Public prosecution, they have
But
basis, my
but
lord.
the latest law says that the victim the informant side victim has to be given a stake in the participatory role from bail till Supreme Court.
My lord, that is why the victim has been defined, my lord.
But
Victim has been defined.
yes.
Victim, there's no doubt, my lord. Victim has been defined.
Anyway, let's
And my lord, and the victim has been defined. So that is why they have a right. Subject to, my lord.
You follow the
Now,
procedures.
he have to follow the procedures, my lord.
No,
He
but
has to-
I've not hardly seen any leave application being filed. Is it necessary?
No, my lord, not leave, my lord. Your lordship has to grant, permitting him to file an objection, my lord. He did not come. It's not that he doesn't come because public prosecutor is there. He has to assist the professor. The court has to give grant this permission. Yes, you file this one.
Okay, that I agree with you. That's true. That will be better procedure. And anyway, I may be wrong, of course. We are learning. I am learning all the time. I may be wrong. I may be wrong also. But whatever little I know, it is the latest judgment. I don't remember the name.
And
But
my
you can, but follow the procedure.
my lord, kindly see what he have to file a cancellation of bail, my lord.
Yeah, cancellation of bail is
What he said, that
still
is a
better.
modification of
No,
the
no,
order,
that's, no,
and cancellation of bail.
See, I'll tell you.
No, no, what he,
I'll tell
my,
you.
what
No,
he submit, my lord.
Don't be
that-
agitated.
No, no, I am not.
Don't be
but-
agitated.
No, I am not agitating, my lord. There is a procedure, my lord. You have
See,
to follow that.
the thing is
You
that
come and stand up and saying all this
that
thing. How it
the-
can be happen?
is an interim bail, but he
It
has
is between the lawyers, my lord.
he has a point. You can enter appearance, of course, verbally that you can file an objection. I give you permission, but specifically bail cancellation is still better if you file an IA. Still better. That is still better for cancellation because 439(2). Let's see, earlier section only. Let us see. 439(2) does not say that it has to be only absolute bail. It can be interim bail also. So that gives you, as I said, that to that extent, Lord Senior Counsel is right. It will give you a better locus standi.
Yes, sir.
You have a locus standi. It's
Yes,
not
sir.
that you don't have any locus, but it will give you a
Better-
your representation will be on better, sounder footing. That's
Yes.
all. That's all. Anyway,
But I will show you, I will show what is the conduct of the informant also.
no issues.
There
No
are
issues.
cross cases also.
Yes, there can be. I don't know, but I should not say because I do not know the facts of the case, right? So that's all. And so what should we do? CD has not come. You file this thing then. No? Okay, you file this much. Have you already filed the objection? Will I?
Objection of cancellation, your lordship. That was filed before the interim was granted.
Third Learned Senior Counsel Pranavara. Full stop. The petitioner was granted interim bail. Is it a matrimonial dispute?
My lord, it is, my lord, it is an extramarital offense, my lord.
Yes.
All are lawyers from the Johar bar, my lord. Informant is also a lawyer. The three petitioners are also lawyers from the Johar bar, my lord. Allegations are very serious, my lord. If your lordship can see the notice, she sent a notice, my lord, pleader's notice, my lord, asking 7 lakhs rupees. 7 lakhs issued to us, my lord. Yes, there's a, my lord, there cannot be, is a rape, my lord.
I mean, would there be any bar in my taking this matter? I don't know. Because I know many of them quite well.
Your lordship.
Ankon Kishore.
You know, my lord.
Ankon, I don't know.
As a Jorhat, my lord.
If they don't suppose given a choice, they won't want me to take it, then I won't take
That's
it.
definitely, my lord.
That I don't know.
My lord, we have every faith on the lordship.
No, that's not
And-
something. They.
Yes, my lord. Yeah, my lord, the complainant is the lady, my lord. And they also in future may also say that we know so and so. That may adversely affect them, but I think so. It's not because of the fact that it's a case of an
Anyway, you file this. Then we'll
cross.
see.
Yeah.
Then we'll see. They should. Both parties should have full satisfaction before a court. Actually,
Right.
Whatever order, whatever comes is another matter. But they should
That's
have.
a different.
They should have full satisfaction.
Definitely, my lord.
But
Being a complainant, I am saying
I
that,
know,
but it's not the procedure, my lord.
Anyway,
The lapses of the
Anup
procedure.
Saikia, Deepu,
Being a lawyer, you should know the procedure.
Vidyut Ranjan, Satya, Vidyut Ranjan Bora. Anyway, they are on interim, so they were granted interim bail on 25/11/2025. Your good name, please.
T. Chetri, your lordship.
T. Chitri Learned Counsel enters appearance on behalf of the informant and seeks to file a written objection. The prayer is allowed. Full stop. The case there is not yet received. Issue reminder. The interim bail shall stand extended to the next date of listing. I won't say anything about bail cancellation. It's up to you. Then we'll see if necessary. I will place it before another bench. No, don't hesitate to say also. No.
Cancellation or.
We'll see, and if necessary, we'll place it another.
The date may be.
8/1/25, 8/26. 8/1/26. After your.
8/1.
After kiba kule?
I think it is Thursday.
Thursday.
Work out your dates. Okay.
38.
Your Lordship. Your Lordship, 482 application. The case has been charge sheeted, Your Lordship. And charge sheet has been made by the learned JMFC Hoja, Your Lordship. Since JMFC is not entitled to grant bail, Your Lordship, we are approaching this court. The charge sheet has been filed after 2 years, Your Lordship, and there is lots of lacks in the charge sheet, Your Lordship. Page number 18.
Scan copy has come. Scan
Yes, my
copy.
lord. Scan copy received, my lord.
Just for a moment, can I have a look at the FIR?
Yes, sir. Page number 40.
What, 376, what is L?
Your Lordship, rape of an handicapped woman.
Handicap, my lord. She is a, my lord, victim is a dumb, my lord.
These
Woman.
provisions have been made very stringent, right? Rightly so, rightly so.
Not even stringent, my lord. He is a, my lord, neighbor, my lord.
No, stringent, I'm saying these laws have been made very stringent.
Yes, yes.
Rightly
Very
so,
stringent,
rightly so.
Very stringent.
It's a double, kind of double crime. Anyway, of course, allegation, I'm saying. You have to see everything fairly. May not be true, may be true. Suffering from physical or mental disability.
Yes, ma'am.
Committing
Yes,
rape on a
my lord,
woman
may kindly
suffering
see
physical and
164, my lord. Interpreter, how, my lord, they are able to, my lord. Very pathetic, my lord. And my lord, in those cases, my lord, that is, my lord, there is a privilege of the pre-arrest bail, my lord.
now case is at the stage of
Appearance.
appearance.
Next date is fixed on, my lord, 19/1/2026. my lord.
And you want me to see the statement of the girl or something? But recorded through
That is
interpreter.
available, my lord.
Interpreter.
Yes, I have flag mark my. Relevant persons, I have flag mark my. Both, my lord, the statement of the informant also and 164 of the, my lord, this victim, my lord.
It should be done like this. Photographer also, no? Photographer. Also.
My lord, they did take, my lord. They filed their affidavit, my lord, before that.
Huh?
Before that, because she didn't, my lord, even understand the sign language, my lord. That
Huh.
is, my lord, in 164 statement, interpreter, my lord, stated, my lord.
Hmm.
But how somehow they are able to, my lord, take her, my lord, 164 statement, my lord.
And other materials?
Other materials, my lord, here, my lord, that is the, my lord, the victim and, my lord, the informant, my lord.
Hmm.
Informant statement is there, my lord.
Informant is mother.
Yes, informant is, my lord, mother, my lord.
Father informant.
Father informant,
Father is
mother statement is there, my lord.
Implicated.
161 statement.
One.
It's true that it is a stage of trial, but anticipatory bail, whether it will be. Hmm. Somehow.
Here, my lord, and they are only, my lord, contention is there
Conscience
in
is
para
not-
11 that the petitioner begs to state submit that he never indulged himself with alleged offences, my lord. So that was the, my lord, that is there, my lord.
Lordship, there was pressure to accept the unborn child, Your Lordship. She is an already married woman. The content of the FIR is somewhat false, Your Lordship. She is already married woman, 38 years of age, Your Lordship, approximately.
Everything cannot be stage managed, right? The interpreter, everything, you know. I mean, human behavior, normal human behavior.
In the medical also, there is no evidence of a recent sexual intercourse, Your Lordship. In the charge sheet has been provided, page number 19.
Because, my lord, that may not be there, my lord, because even, my lord, mother when identify, my lord, if, my lord, go through the, my lord, the statement of the mother, my lord, and things came out.
Mother statement is here.
Yes. Only one minor difference is there. They thought that my lord she's pregnant.
Hmm.
Mother thought. My
Hmm.
lord. The statement says my lord.
Hmm.
But in the medical, that part is not there.
Hmm.
But definitely, my lord, if my lord resent my lord, the part of the intercourse, it will not come, my lord, because identified later part, my lord. And she's my lord, she's dumb, my lord. Victim is dumb, my lord.
The FIR has been lodged after 2 years, 2 months, your lordship, from the date of alleged incident. And as per the pregnancy, it was not found, your lordship.
Hmm. They are indicated as absconders in the charge sheet.
Yes.
The
Your lordship.
Yeah, Mr.
Before
yeah.
passing order, your lordship.
Yes, yeah, sure.
Your lordship, at page
Please.
number 25.
I'm here.
Similarly, at page number 25 of my petition, your lordship. Another coordinate bench passed an order, your lordship, in terms of session tribal cases.
Can be placed before that court then? Should I do that? Can be placed before that court? But the roster is different at the moment, no? Because I'm having a different view actually. Anyway, the victim is not yet examined. Granting bail.
On appearance, he may be protected, your lordship. We are not challenging the trial of the case. The regular trial may be proceeded, your lordship. On appearance, since there are lots of.
Again, my lord, what my limited understanding, my lord. I may be wrong, my lord. My
No, we can always be wrong.
My lord, that is the pre-arrest bail, my lord, that is the applications, my lord. Always, my lord, the honorable court has always that discretion, but always, my lord, one point, my lord, that is the privilege of that person, my lord. His conduct and all other things also may be, my lord, but this is a, my lord, such a serious allegations, my lord. The victim who is not able to communicate the thing, my lord. Mother, when my lord identified, then things came out. And even my lord see the, my lord, that is the informant is not, his status is also like that he is the illiterate person, my lord. So when it is, my lord, that is child, my lord. Father also. That part also, my lord, maybe looks useful.
Anyway. Invoking 482, the petitioner. Done? Anything else you would like to submit? No.
It's up to you.
No, you wanted to say something. Yeah.
As said already.
Sorry.
In respect of page
Yeah,
number.
yeah, co-accused, yes. This, I know this is an problem. I mean.
Lastly, your lordship, the medical evidences are not corroborating, your lordship. In the charge sheet, it has been given. He may be protected on appearance, your lordship.
N. Iqbal, learned counsel for the petitioner, and also learned additional people. The FIR dated 30/12/2021 was lodged in the Hojai PS by the father of the alleged victim girl with the allegation that the said victim girl, who's his daughter, was aged 36 years and whose deaf and dumb was found to be pregnant. And when she was asked about it, she, through gestures, indicated the accused house of the accused. Stuff. Investigation resulted in a charge sheet, and present petitioners are indicated to be an abscond. Present petitioners,
Petitioner, single petitioner.
single petitioners, was indicated as an absconder. Who are the other persons? They are family members. Wazir Khan, Fazul.
This is another case, Your Lordship.
Also, acha, this
For
one.
reference, I've
Oh, it's for,
connected.
sorry, sorry. I don't know, everything will depend. So I thought it was same co-accused. Other family members implicated just like that. Anyway, so now I understood. The case is stated to be investigation resulted in a charge sheet and in which the petitioner was indicated as an absconder. Absconder. And the case is stated to be presently at the stage of appearance. Full stop. The learned petitioner counsel, referring to a similar order of a coordinate bench of this court, submits that the petitioner is willing to face trial, and the court may be pleased to grant the bail as prayed for. Scanned case record was called for and received. On the basis of the same, Mr. Boysa, learned additional PP, strongly opposes the grant of bail and submits that the alleged offense, which itself is of a serious nature, was perpetrated upon a deaf and dumb victim. Full stop. Her testimony before magistrate was contended to be recorded with the help of interpreter, and I perused the said statement.
My lord, there may be only, my lord, only stated as my lord dumb, my lord, not as deaf and dumb, my lord.
Only dumb.
Where?
My lord, the 15 is dumb, my lord, I think, not deaf and dumb. my lord.
Only dumb. Only dumb. Buba. In the FIR it has been provided, Your Lord. Buba Swal is only.
Who's suffering from, don't write dumb, just write who's suffering from speech disability.
Yeah.
Within bracket, unable to speak.
Yes.
Speech disability. All right. Let's stop. There is implication in the statement of the alleged victim recorded before magistrate. As pointed out by the learned additional PP, I have also perused the statement of the mother of the victim, in which she has stated inter alia that upon being asked about the her daughter / the victim took them by the hand and showed the house of the accused. Full stop. Despite the case reaching the stage of trial, considering the serious nature of the alleged offences, not inclined to grant anticipatory bail to the petitioner. Accordingly, the prayer for anticipatory bail stands rejected. Let it be, There's no interim, right?
No issue.
You can appear before it's committed. Is it committed?
Not committed yet.
Appearances,
He can appear before, after it is committed. After he is committed, he can appear and go in and pray for being taken into custody and seek regular bail from them. That, that day we had discussed, not this law. You can try that. That option is there. You're not remediless.
39.
Oblige, Your Lordship.
39, my lord, sitting of receipt, my lord.
May I plead, Your Lordship? Page number 10 is the translated copy of FIR.
No interim. Yes, sir. truck bearing so and so abundant for its discussion. Abandoned truck, no?
Yes,
Some abandoned truck is there.
The case is registered under section 303
Mhm.
and 317.
Mhm.
But the FIR reflects that the person Babul Ali, from his possession, the truck was recovered. He is the scrap dealer. I am not the scrap dealer. Who stole it? He was also arrested. Babul Ali is also arrested. I am not involved in it. Number one. Number two, most interestingly, nobody can dare to stole a truck which is under the custody of police. It was actually misguided by the owner of that particular truck. That particular truck was abandoned under the custody of police since 2019. But as this truck was not within the premise of that particular police outpost, the owner of that truck easily manipulated and did this. But I am nobody. I am actually a driver. I am actually a driver, but I am not involved. It is absolutely straightforward case. My name is not there at all. Not even suspicion is there. But I have, but in my locality, there are many scrap dealers.
Mhm.
And at times we brings
Give
trucks.
some information, as you have written, that he gives some
Yes.
to the scrap dealers.
Yes.
Get some commission in the
Yes,
business.
yes, I get some commission and I am not hiding anything. Just interim may be given because Benetton is there.
Diary has come.
No, the diary not come, my lord. And as my learned friend stated, my lord, he is a driver, my lord. He's a driver, my lord. In the my lord FIR, my lord, is the last part. It is by the clearly stated. It is therefore prayed to kindly register a case under BNS against the driver of the crane and the person who stolen the truck. So, my lord, in the FIR, my lord, though name is not mentioned.
No, it is mentioned. It is mentioned. Driver is Sri Babul Deka. It's arrested along with the crane.
Driver of the truck.
Yeah.
Let us see the original FIR. Let us see the original. Oh, last part, no? Yes.
My lord, here it is stated, my lord, in the vernacular part, my lord. There's the last part, my lord, only relevant. ইয়াৰ পাছত বুহা আৰক্ষী চকীৰ অন্তৰ্গত চিলিকাজাৰ গাঁৱৰ নিবাসী মহম্মদ বাবুল আলীৰ পৰা চুৰি ট্ৰাকখন সাক্ষীৰ সাক্ষাতত জব্দ কৰাৰ বিপৰীতে নগাঁও জিলাৰ ৰহা আৰক্ষী থানাৰ অন্তৰ্গত চুৱেঞ্চ নিবাসী শ্ৰী বাবুল ডেকাৰ পৰা চুৰি ট্ৰাকখন টানি নিয়া ইমান নাম্বাৰ ক্ৰেনখন ইমান গাঁৱত সাক্ষীৰ সৈতে জব্দ কৰা হয়। ঘটনাৰ সংক্ৰান্তত ফুটফুচৰ পৰা দুইজনক কৰায়ত্ব কৰাৰ পৰা জব্দকৃত ট্ৰাক আৰু ক্ৰেনখন লৈ চকীত ৰাখে। So, my lord, it is not very clear.
He is not named in the FIR.
My lord,
He is not named.
Not named, my lord.
Not named.
Not named, my lord. But that is not very clear, my lord.
Not very. I think.
My lord, very short date, my lord.
No, I think it will help to. He can record his statement. I think it will help. It will help. Okay, no problem. With interim, you record. Ask him to go and record his statement. We'll throw some light. Mr. De R.D. Learned Counsel for the petition, and K. Boysa, learned additional people. The invoking 482 BNSS, the petitioner is seeking anticipatory bail in connection with Nagaon PS case number 940 of 2025. Full stop, which was registered under section so and so BNS on the basis of FIR dated 23/11/25, lodged by SI R. Kolita. The gist of the allegation is that one truck AS01 FC 8633 was at Borghat outpost under Nagaon PS in connection with another police case. But on the night of 22/11/25, the truck was found missing, and later it was found that some unknown persons had taken away the truck with the help of a crane towards Guwahati side. Later, both the truck as well as the crane was seized in the presence of witnesses from Babul Deka. One Babul Deka, full stop. Full stop. The present petitioner is not explicitly named in the FIR. Full stop. In my considered view, allowing the petitioner to record his statement might help in throwing more light on the alleged events. Full stop. Therefore, call for the case diary from the concerned police station. However, in the interim, 25,000 with 1 cigarette to the satisfaction of the arresting authority, and subject to the condition that he shall cooperate with the investigation, appear before the IO, making himself available for examination, shall not hamper or temper defense. This is the matter on issue fresh requisition for the case diary. This is the matter on. You can suggest a date.
After reopening, my lord,
Yes.
after 5th?
You
My lord,
can-
immediate reopening or after my
As you-
vacation?
says
My lord,
depending on the dates.
My lord, then 20, my lord.
20.
21.
Item number 48.
May I please your lordship? Lordship, that is a grievous injury case, lordship. Lordship, the incident allegation is purely accidental, lordship. Lordship, kindly come to annexure 3, lordship, page number 16, lordship. Lordship, I'm admittedly submitting that the victim faced injury, and as such, we have paid him around 70,000 rupees for his treatment, and he has recovered, lordship. And I have 2 minor kids at home, along with my wife, and there is nobody to look after them, lordship.
Just a minute. What this is,
Submitted in this matter, my lord.
absconding. Nice.
Lordship, I will cooperate with the trial, lordship.
There was some market or something.
Lordship, that was for purely accidental, lordship, and there was no criminal intent, lordship. If there was a criminal intent, lordship, why would have paid around 70,000, lordship? Lordship, there was, it was purely accidental, lordship. Lordship, the alleged incident took place, lordship, before a butcher, Manoj Setia. I went there to buy chicken, and I was bullied as a dodo, lordship. And there was a purely incidental instigation from the victim also, lordship.
Dodo is a bird. He was called a dodo.
He's a very short guy, lordship. And
Oh, no, it might be, he may be sensitive
very
about.
innocent villagers,
He's
lordship.
a-
These are very
The
innocent.
accused petitioner is a short-statured person,
Very
short-statured
short
person.
person, and he has lost his parents during his childhood also.
No, he may be emotional anyway. Anyway, so let him, investigation is also complete. Okay, no issues.
And otherwise, my lord, that is my lord in the, my lord, that is a.
Case diary or charge sheet?
My lord, it is a search sheet, my lord, submitted.
CDS also come?
No, my lord,
CDS.
CS submitted, my lord, CS submitted, my lord, and my lord, that the allegation is that, my lord, that is in the vernacular part.
And
my
there
lord,
is no doubt against that.
উপর
it is
উল্লেখ
said.
করা
This is the allegation, so we will face the trial, lordship.
পদকীয়াই এখন
We'll
চোকা
defend ourselves
অস্ত্ৰৰে
before the trial.
মোৰ স্বামীক হত্যা কৰাৰ উদ্দেশ্যে ঘাপ মাৰি বাওঁ হাতখন কাটি অসহায় দিয়াৰ লগতে সহায় দিয়াৰ লগতে তাৰ কলা ফুলতো ঘপিয়াই গুৰুতৰ জখম কৰি স্বামীৰ পৰা পলাই যায়. So that is the allegation, man. This is the allegation.
That is true. This is an allegation.
Hand was severed.
Lordship,
Allegation is
maybe,
that,
severe,
my
lordship, I will appear before the trial court, and I will cooperate with the trial, lordship. And there was no previous history of fight between the victim and the petitioner, lordship. And this incident was purely accidental, Lordship. I will defend myself before the trial court, Lordship. I have two minor kids and a wife, and there is nobody to look after them, Lordship. I have paid around 70,000 rupees to the victim for his treatment, Lordship.
Mr.
Arhok, Lordship.
Learned counsel for the petitioner, who invoking 482 BNS is seeking anticipatory bail in connection with Dhemaji PS case number 173 of 2025 under section 12. Section full stop. The gist of the allegation in FIR dated 12/10/25 is that the petitioner attacked the informant's husband with a dao and escaped after causing grievous injuries. Full stop. The learned petitioner counsel submits that though not admitting the alleged incident, even if had taken place, might have had done so at the spur of the moment, and that any part of the moment and in an accidental way, and that there is no criminal intention on behalf of the petitioner. Can I record this? Can I say this? No issue.
Lordship.
The learned additional PP submits that in the meantime, investigation is completed, resulting in a charge sheet against the petitioner, by CS number 172 of 2025, dated 29/11/25, indicating the petitioner as an absconder in the charge sheet. Drawing attention to some the bank documents regarding transactions of money, the learned counsel for the petitioner submits that the petitioner has also paid more than rupees 70,000 to the alleged victim. Full stop. It is submitted that he is willing to face trial, if any. After giving my consideration to the facts and circumstances that have emerged in this case, I'm of the considered view that petitioner can be granted bail, though the allegations is about causing grievous injuries. Nonetheless, it is directed that in the event of his arrest, 30,000 with fund security, the satisfaction of the concern, to the satisfaction of the arresting authority, and subject to the condition that he shall appear before the learned court below on the next date and subsequent dates. He shall cooperate with the trial. Number 3, he shall not hamper or tamper with evidence. He shall not harass or harm the informant/victim side and their family members in any manner. Violation of the bail conditions would make the bail liable to be cancelled. Okay. Allowed and disposed of. His pet name is Dodo. Pet. So he must be unhappy with it or something like that.
41.
41.
Dear lordships, today's picture case diary.
CD not received, my lord.
Oh my God.
Oh,
My lord,
interim.
I am praying for interim prayer, my lord, because lordship kindly peruse the FIR, lordship. Though it is registered case as a, my lord, 117 and 109, my lord, but there is a cross case also. We have also filed FIR. And my lord, similarly, same accused, some of the accused has already been obtained order, bail order, my lord, from this honorable court, because the injury is a simple, which is mentioned in the rejection order also. Lordship kindly see the page 19, rejection order.
According to the FIR, serious injuries, right? But
Yes, my lord. We have also filed FIR also.
diary has come. Not received.
That is why I.
Page.
Because my lord, page 19, because one is 60 years, another is 65 years. Lordship page 19, last para. The doctor mentioned that injury report of the injury victim, injuries are simple in nature.
There's only one victim or multiple victims? Kindly check.
But there are one maybe.
Paul Ray.
Yes, only one.
No, I think. I'll read it again, okay?
Coefficient bail, sir. We have already approached before this honorable court, my lord.
I'll come to that. Deepak Ray, no? Killed my younger brother, struck him on the head with iron, broke his skull.
Lordship, peruse the order passed by this honorable court.
As a result, have caused severe injuries in the head of Prosenjit Trades.
And two accused are 60 years old and 65 years old, my lord.
He says that Azahar says that he has broken his skull. But
Yes,
here,
the head injury, man.
injuries are simple in nature. As a result, his head got fractured.
Simple. That's why I submit before your lordship.
But there is an allegation that the others have sustained grievous injuries. Work by Blantyre. Whereas the photographs of the injured victim provided informant through his objections reveals that there are sharp cut injuries. There is no similarity between the allegation and his grievance.
There is no similarity between the injury report and the photography of the injured victim submitted by the
There is
informant.
no similarity between the injury report. Yes, injury. The photographs reveal
And my lord, in
serious
the-
injuries, but the
Yes.
medical report indicates simple injuries.
The FIR also, complainant himself stated that having taken previous enmity, there is a enmity. Actually, there is a fight between both the parties regarding plot of
We
land.
need to see the medical. Without seeing the medical report,
Yes,
will
sir.
not be proper.
This is your lordship, sir.
Mhm.
Yes,
So,
my lord.
that's it. When can you get it? Should we get it before vacation or reopening? If you can wait, then it's okay. Otherwise,
my lord.
we'll try it on 19th if you have there. Should we? Which Thana?
My lord, it is from my lord,
Gulabganj.
Gulabganj, my lord,
You
Dhuburi,
can
my
take a chance if you want.
Yes, my lord.
19th, we'll take a chance.
Yes.
Huh? Because there is not yet received. Issue reminder for the same. Full stop. The learned counsel, Mrs. Devi, drawn my attention to an observation of the learned court below about the nature of the injuries being simple. Though for some other reasons, the bail petition was rejected. Nevertheless, it would be prudent to have a look at the medical report. So the medical report shall also be procured along with the case diary. List on 19.
Yes.
Take a chance.
9, no?
19.
19.
190.
Yes, sir.
Take a chance.
Yes.
42.
Yeah, please, your lordship. Lordship, today they have filed one objection, lordship. Informant side filed.
Informant, you have appeared.
We have filed affidavit in objection, Your Lordship, but that is not on record. So there is a copy, extra copy.
It has to be brought on record.
Lordship.
You have got a copy.
Lordship.
You've got a-
Lordship may take from 19th, lordship.
No,
In the meantime, lordship.
it will come on record tomorrow also if you want.
Lordship. Then
Extra copy, Your Lordship.
It will come tomorrow also. Let it come on record, I think. What do you say? Formally let it come.
Lordship.
Voluminous. Some land dispute or something?
Lordship, land dispute, lordship.
No, apparently. No, I'm just.
Yes.
But not so simple as for this.
Case of extortion, basically.
Let it be brought on record. Huh? We'll see. We'll take it up tomorrow. Huh? All motion days, so no issues. Your good name, please. No, Achan, take care about it. Ayu Chaudhary, learned counsel for the petitioner, additional PP. D.K. Agarwal, learned counsel for the informant, submits that the informant side has filed an objection. However, the same is not yet recorded, not yet come into the record. Maybe brought into the, shall be done so or brought into the record. His diary is received and shall be written. Then it's no problem. We can dispose it tomorrow. You take this back. Huh? You'll need it.
Deeply obliged.
No, not dispose. Tomorrow.
Supplementary 54.
Wait, that's on, it'll break.
Directly allowed.
It will be so, admission start with.
Maybe the lawsuit. It is a bail application lordship.
Yes.
Earlier it was non-affair case, thereafter my learned friend discloses the case
Yes,
number.
there was a case. number.
Case number of thereafter I have certified, I have received a certificate to lordship from the lower court lordship. And three sections my lord registered, almost all are available lordship. Section 85 is there, that is earlier 498 lordship.
Only that is non-billable.
Yes, lordship. That is punishment only up to 3 years. Maximum punishment may extend to 3 years, lordship. So my lord, custodial injunction may not be required, my lord.
You are for?
In this case, Papi Ahmed, informant, is not impeded as a party, my lord, in this case. And she has approached to the legal aid office, my lord. For giving,
It is required, lordship.
my lord, she may be impleaded as a party, my lord, because he wanted to file objection, my lord.
He has approached legal aid of this court,
Yes, my lord.
this court,
Yes, my lord. High
or
Court.
DLSA,
DLSA, my lord. My lord, Guwahati High Court Legal.
Legal
Office.
Services
Yes,
Committee.
my lord. An appointment letter has given, my lord,
office.
for appearing on behalf of informant Papi Ahmed.
You.
I have got it, my
Oh,
lord.
I see.
So my name may kindly be.
Yes.
An objection will be filed next to that, my lord.
The available section is dear lordships.
All sections are except 498A.
80, yes, lordship, that is maximum up to may extend to 3 years, lordship. So my lord, custodial injunction may not be required, lordship. Yes.
I'll record your submission, don't worry. And should we, how much time would you need to file a reply?
1 week, my lord.
You want it before vacation or after
No,
vacation?
I'll leave interim permission may be granted, lordships. Custodial injunction may not be required. I will apply before the police, lordships. And matter may be fixed after vacation,
In that case, you'll have to help me with the FIR. We'll have to see the FIR once.
Lordships.
FIR is here. Details are not available.
I need the FIR, my lord.
Oh, yes, yes, yes.
I have the
FIR.
affair,
My lord.
In the meantime, you have the FIR.
Yes.
We received the, my lord, CD, my lord.
Mhm. Okay, CD, it will be available in the, is there?
Yes,
also?
CD is available, man, very nascent stage, my lord.
Just let me. Available here also.
My lord, the petitioner treated the informant, my lord. Earlier, he is married, my lord. He is a married person.
Sure.
And he very secretly he married second marriage, my lord, that done before the notary, my lord.
Notary cannot be a marriage, lordship.
And also Nikah also done, my lord, in Tamulpur. There is an FIR, my lord. I have not gone through the petition, my lord, because copy is not ready and.
Then how can it be 498? It can be.
Yes.
They are not, they are married. They are not
My lord,
married. They have a relationship.
My lord, they are married before
Acha. Kazi.
তামুলপুর থানার অন্তর্গত এখন গাঁৱত মোক নিকাহ করায়
That is the election only, lordship.
নিকাহ
Actually,
করায়
they were the.
যোৱা 1 ছেপ্টেম্বৰ 25 ইংৰাজী তাৰিখে ইছলামিক চৰাচৰিয়ত মোতাবিক মোক মফিজুৰ ৰহমানে নিকাহ কৰাই মই পূৰ্বতে লোৱা ভাড়াঘৰলৈ আনি আমি দুয়ো স্বামী স্ত্ৰী হিচাপে যৌথ জীৱন আৰম্ভ কৰো।
She is also married, having one child, lordships. She is also
Then
married.
later she came to know that he was already married.
She is also married, lordships. She has a child also.
Well, that's
Well,
okay.
when
No, my lord,
the-
my
when the
submission.
notary is done, there is a your statement is recorded in the notary, my lord.
Yes.
That the second party is a divorce having one minor,
Yes.
namely Mamun Rasid, aged about 14 years old. Both parties know about.
Basically, my lord, why this case has been filed, lordship, actually she wants to restart a marriage before the my lord marriage officer. But this petitioner could not do that because he is busy in the business purpose. So my lord, this election, that's why
But
this.
the informant is not known that the petitioner is already married. He has a family in Nunmati, my lord. And he has done conspiracy.
Madam, my
While
submission is that
ex-
army will not
before
take care of the
execution of-
police, everything will clear, lordships. Available section, lordships.
My lord,
And-
their physical relationship goes to that stage that she became pregnant, my lord. And abortion is done, my lord.
Who has done? I have not done lordships.
My lord, abortion is done on instigation of the petitioner. my
No,
lord.
that cannot be lordships.
And in the FIR it is reflected, my lord. And it is the most,
I will cooperate in the investigation lordship.
and why the informant is not included as a party, it is a very question of. fact,
My lord, this is not a SI lordship. POXO case, it is
What?
mandatory lordship. It is
What?
not a POXO case lordship.
FIR is
No, it's
lost by
not-
the
that is
informant,
the-
why he is not
No,
included as a party?
it's still not mandatory. I
Yes,
think,
Lordship.
except POXO and all that.
Yes, lordship.
Anyway, so
So interim may not be granted, my lord.
learned counsel for the heard
not
Mr. Hawk,
part.
Mr. Hawk, right?
Lordship.
Learned counsel for the petitioner. Full stop. So who submits that apart from section 87,
85 lord.
85,
There is earlier 498.
earlier 498A IPC. The other sections are bailable.
Lordship.
Uh, yeah, named, good name, please. Yeah.
Begum Roshan,
okay.
BRA Sultan.
Yeah, BR, full name is. Yeah, Sultana, learned counsel, enters appearance on behalf of the informant, Papia Begum,
Papia Ahmeda.
Papia Ahmed,
Ahmeda.
and submits that on an application by the informant before the office of the Guwahati High Court Legal Service Committee, she has been entrusted with the brief to appear for the informant. The name of learned counsel is Ms. Sultana, full name shall be reflected in the cause list. The case diary has been received. The learned counsel for informant seeks to file a written objection. If you can do it this week, we can dispose it off since case diary is available.
My lord, your lordship kindly fixed that.
Can you,
In the meantime,
if you can you file it?
Objection, written objection.
It
Against the bail application, my lord.
says after no, only 4 days we have.
Lordship.
19.
19.
Try it.
19, yes, I can do that.
Try it. File it and give it to him immediately.
Well, I may protect your lordship because I am not in the home, my lord. So since long, this case is pending, lordship. So my lord, bailable section, lordship. If I am arrested, lordship, this
So,
matter will be in process, lordship.
If interim is given, then
Lordship.
Mr. Boysa, if interim is given, then we might as well fix it in the first week.
Lordship.
First week. But she's opposing the interim. You feel,
But it's a bailable check. That's why I am praying, lordship.
In this case, my lord.
can you record the statement within 4 days? May not be possible. May not be possible. The cycle may not be complete.
My lord.
Yes, tell me.
My lord, the material FIR, the contents of the FIR does not support that he may be released on interim bail, my lord.
My lord.
Uh,
Actions are available, lordship.
learned counsel representing the informant submits that the circumstances may not justify grant of entry. It may be mentioned herein that as per the allegations in the FIR, the accused petitioner entered into a relationship with the informant, leading to her pregnancy, which was subsequently aborted at his behest and and that the informant also came to know that he was already married with a family and children. Anyway, fix it on like 3 days. Okay, fix it on 19th.
19 December.
CDB retained.
Master Black.
So just hold on 4 days, then we'll see on Friday. You file and then
55.
case diary be retained. Just retain the case diary.
55.
Let it be. Prima facie conduct is not good actually. So, yeah.
Yes, item number 51, the NDCPD bill application CD was being called for.
Yeah.
Last occasion.
Mhm.
Isn't it?
Raju Khan.
55 minus meaning of receipt. Sir, I would like to press for the interim in this case because the losses has already gone through the entire case. There are 3 FIRs. Okay. In the first FIR 5/11/2025 at page 28, he made his wife an accused along with the petitioner. Again, subsequently, this was not being registered by the police being suspicious. Later, a FIR was filed by the petitioner's mother on 8/11/2025 against the informant. Later on, after the FIR has been registered against him, he has filed the FIR on 9/11/2025, making the wife as a victim herein. That is at page 15.
Yes, this I've seen.
Yes.
Informant.
Out of the fearing incident, he has made his wife a victim in a FIR. One, he made a accused in the.
This was filed, yes, now I remember this. It was, yeah. Diary, not received. This was to give, otherwise prima facie, these are, get the case diary, which Thanas? Nagaon.
Nagaon, my lord.
Get it? No, get it? When? The going by this FIR, the interim is a bit difficult because there's a threat of viraling, and using that, he has forced her into relationship,
Lordship, the initial FIR that has been lodged by him has made a GD entry in the Morikalan case. I have made on page 28. The contents of the FIR in that particular incident is completely different. At page 28. In this regard, a Morikalan POP by GD number 72 dated 5/11/2025 was being made. The content was completely different. He was beaten by his wife. Thereafter, on 9th, he made an allegation that he has been blackmailing his wife. This clearly shows that it's concocted story.
Get it within this week.
Okay,
19th.
on 19th, it's not possible. I will be out of station.
You may be out of station. 18? 18, I have a lot of matters, but still I'll accommodate you. No problem.
I will be moving.
18, Nagaon PS, 3 days only. If it comes, very good. Because
Or my lord, immediately after reopening.
no interim, then I'll have to do a comparative study of the two FIRs.
Because my lord, allegation is very serious.
Yeah, first FIR allegation is quite
Yes, ma'am.
serious.
Yes.
The first FIR is on 5/11. It is on page 28.
With due respect, I would like to. Can you read the FIR dated 8/11? Save us time, kindly go through it. Let us go through it.
8/11 FIR has been filed by the petitioner's mother.
Yes, that's what. Let us read that because this one I have gone through.
Yes.
This one I have absorbed the facts by and large. With due respect.
Due respect, I would like to inform you that on 5/11/2025 evening at about 6 p.m., the below mentioned accused person called through phone numerous times to my son Raju Khan. Therefore, my son Raju Khan went to meet them. As soon as he met them, the accused persons assaulted my son with lathi, iron bar, etc. In the assault, my son got grievously injured in his eyes, neck, back, and head. At that situation, the accused person looted away from my son Raju Khan the gold chain he was wearing, his mobile phone, and rupees 15,000 from his pocket. It is pertinent to mention herein that the accused person owes rupees 1,50,000 to my son Raju Khan for digging phone. They called him continuously through phone to take away the said money. Therefore, requested to register a case against.
They called him continuously through phone to take away the said money means.
He has been called there.
To return the money.
Yes, to get the money that he was being about to get from that particular informant. He was about to give 1,50,000 to Raju Khan, that is the petitioner. So he was being continuously called to take away the money from him. And after registering this FIR, Lordship, on 9th, he has completely finished the facts of the case and registered a case against him in regards to rape.
Can we see the timing, this timing of the two FIRs? Timing. While you check that, I will read this because just.
One is my lord, that is 8/11, my lord.
And that FIR has been registered under extortion, grievous hurt, Your Lordship, against the informant.
Hmm. In fact, there may be elements of truth in both the affairs. You know. Over this incident, he might have been beaten up or something.
Lordship,
Anyway,
call
on the
for
same day. Isn't it?
That may.
Lordship may call for the CD for this case also.
Anyway, for the moment, let us take a chance. 19th, you won't be there.
No, on 18th also I won't be possible also.
Then we'll have to fix it after vacation. You know, after vacation.
If
Please
your Lordship may kindly grant interim-
no interim. Sorry, I am
Yeah,
won't be
otherwise, Your
possible
Lordship, you have to fix, I have to,
because
ask
it will be
somebody to
because
attend.
it will be very difficult because you know this prima facie we have to go this because I am not finding this
Lordship
I
may
can
take out on 18th, Your Lordship.
on the
If I
face of
cannot-
it may not be a counterblast also anyway. So 18th I can fix 18th or 19th I can fix
On
if you
18th,
can
Your
manage.
Lordship. 18 I can
18
somehow manage
yeah,
somebody.
so no, I mean your convenience is also important. 19th, 19th is better. No, won't be possible. But 18th, there are lots of matters. It will come below. But we'll try. Okay. But 3 days, I doubt whether it will come.
Today already, my lord, today only
Not-
17 we had, my lord.
Yes, yes. No chance. No chance. No chance.
Immediately after reopening.
Immediately after.
Immediately.
5-1.
Fine.
Call for the case diary of
Fine.
case diary is not yet received. Issue reminder for the same. Should we call for the other case diary also? Both the case diaries.
That may be
Huh?
called also, my. Yes, that may be
Also call
because
for the
those things are related, my lord.
yes, yes. Also call for the case diary of case diary of no Nagaon PS 897 I think. 897 of 2025 under section so and so.
My lord, now, my lord, present is 898, my lord.
Yes, the earlier one is 897.
Earlier one is 898.
Sometimes it's very difficult to know. Good. Anyway, 5/1/2025.
Your Lordship, he's a government employee, maybe granted interim.
Government employee also.
At least, Your Lordship, interim field next date, Your Lordship. If something comes against him, it may be vacated, Your Lordship. He's a constable in the Assam Excise. Your Lordship.
It's-
It may be vacated if.
How come it is his FIR is earlier in point of time? No, the case is number is earlier in point of time.
It was filed earlier, Your Lordship.
Yes, sir. That is your contention. But number is also earlier.
Three sets of FIR, my lord.
Huh?
Three
We
numbers
do
of
not
FIR.
know actually anyway.
And my lord,
Because sometimes
how related to each other, my lord.
but this one is clearly before, isn't it?
Yes, my lord. Now he's before us is 9/11, my lord.
Ah.
9/11 we have, my lord.
898 is the FIR where he is seeking bail.
Yes. my
In
lord.
897 is the police case which was registered on the basis of their FIR,
Yes, my lord.
isn't it?
But my lord, 897,
Current counsel for the petitioner submits that the present FIR, though involving grave allegations, sorry, no allegation. Present FIR has been filed as a counterblast to the FIR dated FIR lost from the side of the petitioners against several accused persons, including the
Informant.
Informant of the case lodged against the present petitioner. Full stop. In the FIR lodged against the present petitioner, the allegation is about illicit relationship and exploiting the wife of the informant with some improper videos and pictures to blackmail her into physical relationship. On the other hand, the allegation in the FIR stated to have been lost from the side of the petitioner is about assault of Raju Khan, the present petitioner. On the basis of the FIR lodged with regard to the alleged assault of petitioner Raju Khan, Nagaon PS case number 897/25 was registered. And the FIR lodged against the present petitioner Raju Khan was registered into Nagaon PS case number 898/2025. In the backdrop of some in the backdrop of the complex factual matrix, perhaps allowing the petitioner to record his statement would help in the investigation as contended by the petitioner side, the learned petitioner counsel. Therefore, though on the face of it, the allegations in the FIR against the petitioner are of a serious nature, nevertheless, for the reasons stated above, it is directed that in the event of arrest of the petitioner in connection with this petitioner Raju Khan, in connection with this case, he may be allowed to go on bail of rupees 25,000 with one severity of the like amount, subject to the cooperate, appear before IO for recording, shall not harm the informant side in any manner. Call for the case diary of Nagaon PS case 898 as well as 897, Then you can but fix it in the first week of Jan, because we do not know if the other FIR is not so correct. Then these allegations are serious, as we have discussed.
This minor, that is the 911 FIR, and minor, that is the where JD entry is 611. Both are minor connected. There is no dispute.
Connected itself.
Yes, these are connected.
Maybe elements of truth in both. Maybe.
Yes, ma'am.
So get them 897, 898, both. And 881. Date
Then minor the 81 minor. 8 minor. 8 or 6 or any date. minor.
7.
7.
Short break. I'll just come. Four.
Lordship. I'm led by Mr. Learned Senior Counsel, Mr. K. Chaudhary, in this matter, Your Lordship.
Okay.
Matter
You are
may
for
be-
the, okay, acha, admission matter.
Admission matter.
Yes. Additional affidavit you have filed.
We have
Or-
filed regarding the.
The charge sheet.
On record.
Charge sheet. Yes.
That is filed, Your Lordship.
Yes.
That is brought on record. Your Lordship.
Tell me.
Lordship, and date may be fixed, but however, Your Lordship, the case has been registered, as the charge sheet has been filed, Your Lordship, it's
Mhm.
pending in the Honorable Judicial Magistrate's Court. Date is fixed on 30th of the
Mhm.
December this year, Your Lordship.
30th of December.
30th of December.
30.
30. Till the next date, the proceeding may be stayed, Your Lordship. Therefore now.
There are a number of accused in this matter, my lord. Stay your proceeding, my lord, without hearing on merit. Not, I am for the informant bank, my lord. They're serious allegations. Let this matter be heard after the
This
vacation.
matter,
It's a matter of 2024, Your Lordship. The state was given.
will it be possible to dispose of at the stage of admission? Because it may necessitate a hearing also, isn't it?
Was there a admin as,
All matters are not possible to be disposed
10
at
accused,
admission.
10 accused as.
Or we have to, Acha, 10 accused.
10 number of accused.
Sir.
He is only for one, they are only for one, but
Acha.
please stay.
What is
without-
the, you can just in a very gist, nutshell, you can tell me about the allegations. Or I can also see, we can see the FIR.
Yes, your lordship, the
Or you
page
must
number
have written in your petition also,
page number 25, your lordship.
25. Grameen Vikas Bank,
Grameen Vikas Bank, your lordship.
what is that? I'll read it myself, don't worry, it's too, not very long. I'll go through it myself.
Yes, yes. That's it. Informed.
The present petitioner is
Omlan Jyoti Bhuiya, your lordship, the bank manager.
the main accused. Main accused. The bank
Yes,
manager.
He is one of the men.
Yeah, he's the
That is-
main accused.
Fact-
But on what grounds you're seeking caution? Because it has so many
Lordship,
facts,
the fact that now-
disputed facts.
Yes, your lordship, but the lordship, the fact now is that the total outstanding as on date of the, all of the loans given is only 2,32,000, your lordship. 2,32,007 rupees, your lordship. Till date, everyone is paying their dues. When normally a fraud is committed, your lordship, they don't reimburse the money back to the bank has already acquired more than they have given the loan, your lordship.
Let us see the charge sheet once. Can we have a look? Mr. Boyso, you are appearing? for this thing? Yes. No, it's voluminous. This the charge sheet, can we have a look at the charge sheet? Charge sheet is on record now.
Yes, your lordship.
Mr. Ganguly, charge sheet is there.
Page 409.
The additional affidavit.
Just have a look. Affidavit in reply also fine. 409. Just, prima facie, there are many disputed facts and documents, isn't it?
That would require, my lord, the trial to be held. He's in the view of the allegations, number of documents, number of witnesses, number of accused involved.
On the face of it, yes,
On the
they have to
face
show
of it.
something. In a case of this nature,
Something-
washing has to be there, something,
Lost,
you know,
lost.
something,
Something sterling,
something terribly wrong with the,
Lodge. That is what.
something of that
If
sort,
you want-
apparently, you know.
If they want to argue.
I cannot prejudge, of course, but apparently, that is the thing. But many of these things are, you know, disputed on both sides, you know, just maybe. So
The date may be fixed, your lordship, for now.
it's okay. What do you say, after vacation? After vacation, will it remain at admission stage only?
Yes. Yes. Admit provision.
It is now before CJM, Kamrup.
Yes, sir.
That is his input. Yeah, yeah.
It will register at PRC case number 3480/2020.
For Mr. D. Chetri, Learned Counsel, for the petitioner side, and who is appearing to be on behalf of Learned Senior Counsel. Mr. K. N. Chaudhary, would be leading the arguments from the petitioner side. Mr. Chetri seeks an accommodation due to inconvenience of the petitioner of the Learned Senior Counsel. Full stop. Mr. A. Ganguly, right?
Lodge.
A. Ganguly, Learned Counsel, appears for the informant Ugresh Kumar, General Manager, then General Manager, or now also is General Manager? General Manager, Assam Gramin Vikas Bank, at whose based the FIR was lost, alleging anomalies and fraudulent activities with regard to loans in Assam Gramin Vikas Bank. The present petitioner stated to be the manager of the bank, K. Boysal, Learned additional PP for the prosecution. Please place the matter in the admission column in, you choose a date, choose a date.
Any date immediately after opening, your lordship, any day.
Nine.
Let it go after Bihu, my lords, if I may.
That would be
No problem. If you work it out after BU, then it can be after BU also.
on the first week if possible, 9 possible. if
Nine.
possible.
Ninth will also be, anyway, I won't say, I'll leave it to you. You suggest me, fix it.
9th.
9th or 19th. If it's after BU, it can be on 19th or 20.
Let it be on 9th, your lordship, if not an inconvenience.
No, I don't know my list, so I cannot say.
Otherwise is the motion day means Friday.
Then 8th, your lordship.
So hearing, they actually,
I have
we
some-
should give importance to the hearing matters, otherwise they will never reach. You know.
First
We
hearing.
have to
day.
work out some balance. Let's see, thinking.
Or on 20th, my lord,
Yes,
the
sir.
hearing day.
20th,
If not an inconvenience on 6th, if possible, lordship. I will not.
because the 6th will be too early. Actually.
Early, my lord, too
No,
cold.
not, nothing like too early, but.
Let it go after Bihu, my lord. It's too cold in the first week of January.
Hmm?
Too early, just after the break. The matter which requires some hearing, perhaps. Let it go after the Bihu. It's mine.
Then on 27th.
When?
20th? 27. 27. 27. 27 one.
27 one.
Much obliged.
But read it, I know, I mean, whether it'll, whether it'll be possible, to what grounds we can, by seeking quashing, because it is documentary evidence, disputes, disputed documents, many things, contentions, counter contentions and all that.
Yes, Your Lordship. Much obliged.
Because appreciation of evidence, the moment appreciation of evidence starts, the quashing jurisdiction
Becomes a bit difficult.
ends almost.
Limited.
Item number 6.
May I please, Your Lordship? Lordship may recollect the issue that carrying of gold without a valid document, my lord, without any document. So, Lordship has already heard the matter at length. So, to refresh my memory, my lord, so I maybe start from.
Yeah, this was, I
page
heard,
13.
but the part heard, it's not written.
Is,
Vaishnav, Mr.
on the
Vaishnav.
earlier occasion, it was written as
You had
part
also
of-
argued, I think. You had also argued, I think. Present the prosecution, I think you have not started.
Yes.
But he has argued, you're right. You remember your case offers. But I should have written part heard here.
Yes, my lord. But on the earlier occasion, it was written as part, I think.
Acha, acha.
But it was not released, but not showing in the cause list as part.
Mhm.
আগৰ date বিলাকত আছে না? আগৰ
Not part heard, but there was a submission. Actually, it is wrong. I mean, we should have written it more clearly. There was a submission before my sister Jahan that it was heard, so it may be placed before another
your
bench. So
lordship-
he said that
Your
it will
lordship
placed
has
before
also
me.
heard it.
Yes,
on
but
2 occasions.
yes, that's why it's actually my error. I should have written part heard.
But I pray for next date, my lord. Today, my lord, I am not able to go through that, my lord. That thing, my lord.
Only question was that,
Sometime.
on the last occasion, lordship was putting that whether any penal offense was there, if a person carries the gold.
Oh,
Oh,
that gold matter.
Yes,
Acha, acha. Mhm.
without any document, whether it can be a penal offense.
And that's why you are seeking. Now I
Yes.
remember.
So there was basically in IPC and BNS also, there are no penal provisions regarding this, my lord. So
The case
that
is
needs to be
the
satisfied by the
case
learned
is
people.
charge sheeted, right?
Yes, it's search sheeted
And at the stage of
at the stage of charge, framing of search, framing of search.
stays there.
Yes,
Stays-
it stays.
Hmm.
The charge sheet has been filed.
Hmm.
So there is no evidence basically. No witnesses were there.
Oh, sorry. You have already argued, and Mr. Prosecutor seeks some time, so he must be
Very
tired
may
also.
not be opening, my lord. Any date may be given, my lord.
Again, my lord will have to hear the matter at length.
No, it's when our memory works like that,
Yes,
As
my
soon
lord.
as you said goal, now I remember.
Yes.
It works like that, something relating to something. I remember now, in fact, it has come to my memory. So that is true. But anyway, I have to give him some time, isn't it? I cannot force him now. No, because that was the issue, right? What penal provisions will come? The Customs Act penal liability is different.
Now it is, my lord, PNS.
Yes. Actually, you heard then Mr. appears for the petitioner, Mr. Medhi appears for the petitioner, and K. Boyso for the additional PV for the prosecution. Full stop. Upon perusing the case record, I find that on 9/12/2025, the learned counsel for the petitioner had already addressed his arguments and conclude the same before this court with a liberty to submit a reply. Full stop. However, at that time, the matter was not mentioned as part heard. Full stop. The learned additional PP submits that he could not prepare the file today, brief today, and seeks another date. Prayer is allowed. Full stop. The matter may be kept as part heard. Part heard word to Bol Kudil. Is the interim order passed by the order dated so and so stands extended till the next date of listing. If you get time, you can, I will also, sorry, three of us.
Immediately
You know
after
that
return-
you just search three of us, any whoever gets some material will be good for the hearing. That what is the criminal liability under Customs Act? Whether it is any relatable to this. Otherwise, he prima facie, he makes a point that Customs Act is not there. So other materials should not, lead to prosecution. It might. Yeah, I'll fix a date, but don't worry. This you have given, no? This judgment. Oh,
Yes.
Bhajanlal is state of 19. This is the matter. This is the matter on, you tell me, Boyso.
6.
This can be on 9th maybe. Again, 9th also will face some, because of another.
6 open again.
9th.
Okay, 9/1/2025.
Maybe at 2, my lord, if possible.
No, keep that open. Keep that.
My lord, my lord.
Keep that open.
Regional 7,
Mas open.
7th of the 9th. 7th of the.
DV maintenance matter. DV.
Yes, DV maintenance. Lordship, basically this petition is originated from the case which is pending in the JMFC of Kamrup Metro. The genesis of my petition is that the adult daughter under the DV Act is not entitled for maintenance.
Adult daughter.
Adult daughter, which is defined in the section 20 of the DB Act, that the wife as well as her children, if any, are entitled for maintenance. And the children is defined in the section 2, that is the below of the age 18 years. But in the impugned order itself, the magistrate recorded that her date of birth is 2003, 4 March 2003. So when the order was passed, the daughter was itself at the age of more than 21 years.
Well, you must have studied all these things, but still, I think most of these issues are settled, I think. Will she also not get if she's unmarried also? I'm not
No,
asking.
she
I have to refresh. Unmarried adult daughter, suppose.
Unmarried adult daughter.
Then will she get?
Lordship, the issue
We'll
is
have to
that,
check.
Lordship, the issue is that
Refresh. Yes.
she is studying in Bengaluru, and being a father, I am bearing the whole educational expenditure. Even then, I am ready to pay the 4,000 because she is my daughter. I have
Yes.
some responsibility. I am not at all denying the payment. Even then, if required more than 4,000 also I'll pay.
That's right.
But I have a dispute with my wife. I have not a dispute with my daughter. But why should I shall deposit the 4,000 in the hand of my wife in the court of law? Because she is even not entitled to seek any kind of maintenance on behalf of the adult daughter. In fact, I am.
Yes, that could be one point. Is that the domestic violence is with regard to the wife?
Wife, but daughter, she is very much attached with me, and I am taking care of her.
But DV account, no?
But in this, case, what happened, Lordship, the wife, yes, she may go to the court, she has a right. If she thinks that she is inactive, but she is not entitled to claim any monetary benefit on behalf of the adult daughter. This is my case, this is my case. And Lordship will find that magistrate recorded that her date of birth, which is mentioned in the petition itself. The order itself reflects that at the time of passing the order, she is around 21 years old. Again, the magistrate has ordered the interim relief, interim maintenance for the adult daughter. And I have placed all the relevant documents that I am bearing her expenditures while she is staying in Bengaluru. I am giving monthly 20,000 as a tuition fee and all other expenditure.
থাকিব লাগে পাতল নহয় বাৰু এটা।
I have a copy, Lordship.
I'll take again in the meantime, Mr. Das will find you. I can just have a look. Otherwise, we can always download from indiacode.in, a very good website of Government of India, Law Ministry. Nice PDF is available. We can always download it from whenever we need it. I'll have a look.
Yes,
at your section.
please.
Oh, got it. We got it. Thanks.
Lordship may peruse the section 20.
Hmm.
Within bracket 1 within bracket D.
20 within bracket 1 within bracket D. No, we'll find a case law for this kind of actual situation. We'll definitely find a case law, and I had found actually. Now I'm not recollecting. I remember reading something of this stuff.
That Lordship, that part, the statute is very clear.
Just a minute. I want 12. I'm just having a look at 12. Service, residence orders, protection orders, monetary reliefs.
It is candid and clear that children, if any.
Mhm.
And Lordship may peruse the section 2A, which says that children means below 18 years of age.
Maintenance and our children, if any.
Yes.
And now definitely where below 18 years?
To section 2.
Definition. Definition.
Yes. Section 2B.
Child. So it will cover the definition of children according to you in this. Oh.
Lordship, one thing is that since I am not denying any mode of payment, any maintenance, because being a father, it is my responsibility and duty towards my daughter to maintain her and to bear the expenditure of her education. In fact, I am doing this. But my issue is that I shall not deposit the amount in the hand of the so-called aggrieved wife.
But if a payment within the ambit of DV Act will have to go through that because the foundational fact is commission of domestic violence.
No, yes, there is a
which has caused some loss to the aggrieved person. That's why I refreshed.
I'm paying 3,000 for the aggrieved person as per the order. I'm paying that amount also.
But you don't want to pay for the daughter.
Yeah, I'll pay for the daughter.
But not to the hands of
to the hands of the wife. Because such kind of payment is not
who's will need the other side.
On last occasion also they were absent. Lordship, can it be modified the order that I will deposit the amount in the bank account of my daughter, and if necessary, I'll produce the relevant
because I think for that also the will They have appeared, no, once?
They have appeared,
They have appeared.
not once on repeated occasions, but
Same Mazumdar.
last two occasions they were absent.
Mr. Biswas and his team. Mr. Appeal against the MP order. Come after a long time. 1712, then 912.
On repeated occasion. I
After
made-
1 year it has come.
on repeated occasion, I made application for listing.
No, no, it's okay. That's none appears.
Okay, another aspect of the case is that suppose that I have deposited the amount in the case. And I have filed an application that the amount shall not be handed over to the mother of the daughter because she is not a child. She is an adult until or unless someone is authorized, then he or she may not be in a position to receive any amount on behalf of any adult person. So it will create a more complication. That is why I am not denying the payment because she is my daughter.
But you want to pay in her account?
In her account directly, and if necessary, I will produce the
That may be
payment slip
possible.
in the court of law.
That may be possible, but I think one date we have to definitely keep for their appearance. No, it will not be
It is, the parent case is fixed on 20th of December for payment. All right, Lordship, that on that day I'll manage somehow.
No, not manage. You can just.
And I'll file an adjournment
I'll
petition.
I'll adjourn. I'll.
Until
Can I record your submission? I can record your submission that is willing to pay.
Yes,
to-
that can be recorded. I am
That-
willing to pay.
Take a
I will
certificate copy and
deposit the
something.
amount in the bank account of the daughter.
Mr. Mazumdar, no?
Yes.
Mr. Mazumdar, Learned Council.
In fact, I am paying Lordship.
Paying
per
for the
month
petitioner.
20,000.
However, full stop. As per ordered, full stop. As per order dated 17/12/2024, the respondent / aggrieved person is represented in this case, in this proceeding by Learned Counsel SC Biswas. However, none appears today on behalf of the said sole respondent. Full stop. The petitioner has invoked section 482 of the CRPC against order dated 22/4/2024 passed by Learned JMFC in DV case number 110 of 2023. Granting by the same order, wife was also granted,
Yes, that amount I am paying directly in her hand.
granting an amount of rupees 3,000 to the respondent and rupees 4,000 to her daughter. Full stop. It is submitted that the petitioner is regularly paying the amount of 3,000 to the respondent and that he is also willing to pay the rupees 4,000 to his daughter. Full stop. However, as the daughter is a major, therefore, the daughter is a major as also reflected in the order, impugn order of the Learned JMFC. He desires to pay the said amount in the bank account of his daughter directly. Full stop. Full stop. Next paragraph. This is fine, no? This is
Yeah.
recording. It is submitted that if the order is modified to that extent, the petitioner would be satisfied with that relief as well. Full stop. However, as none is appeared on behalf of the respondent, another date has to be kept. So we'll hear it immediately after vacation. Because, if you can tell sir that we can take it up tomorrow, day after also, though we are hard pressed for time.
My submission is that
He may be unable.
I may be allowed to take adjournment.
No, you place an order, this order before the court. That will serve your purpose. That's why I have recorded also for refreshment and also for that purpose.
And one more thing may be recorded. I am taking care of her, paying per month 20,000 as her educational expenditure.
The petitioner counsel also submits, Mr. Mazumdar also submits that on his own accord also submits that on his own accord He is already paying rupees 20,000 to his daughter. It is submitted that the next date in the DV proceeding before the learned court below is fixed on 2025. Sufficient. Next date, when should we fix it? After vacation?
Lordship, the date,
Release the matter on
9, 10.
7.
In fact, Lordship, perhaps I have to submit that I have instruction from my client that even then he is ready to register all his belonging property in his daughter's name. Not his.
He will need something for his for himself also. Anyway,
Item number 8,
that is up to him.
No, please, Your Lordship.
Not much time, no? Just
Right.
introduce the matter. Let's see what happens.
Suspect number 2 was supposed to file his reply, he has not yet filed.
Someone has appeared
Last, now they failed.
last year.
Last
time
occasion they
they had appeared. A. Mahmud. A. Mahmud. Check case, no? Check case.
Check once, we challenge the proceeding.
I think we'll have to, they will need them, I think. Time is, I believe. Mr. Ahmed, you,
I'm Kolita Lodge,
eh?
J Kolita.
J. Kolita, Learned Counsel, appears on behalf of the petitioner. Full stop. The TCR is available. And on earlier occasion, Mr. A. M. Ahmed, Learned Counsel that appeared. A. M. Ahmed, right?
Last occasion.
It is mentioned as A. M. Ahmed.
In the orders it is mentioned.
As had appeared on behalf of respondent number 2. However, none appears today. The interim order, white order dated 25/11/25 shall stand extended till the next date of listing. List the matter on after vacation. After Bihu.
Bihu vacation.
After Bihu. After Bihu. 21.
Lodge, Lodge. Okay.
21/1. 26. Go for the mentions. Order matters I could not touch. Hearing was so there. Not practicable. Might be the orders,
44,
Time permits, otherwise you take date.
Lordship, in this matter, Your Lordship, on several occasions, notice was issued to the respondent number 2, Your Lordship. On last occasion, Your Honor, on 25/10, Your Honor, Honorable Court was directed to issue notice in area of publication, paper publication. And in compliance of order, Your Honor, I have already published the notice, Your Honor, and filed
Okay.
an affidavit, Your Honor, additional affidavit.
Your Mr.
Yes.
A. Hussain, Learned Counsel for the petitioner, submits that in terms of order dated ... substituted service has been resorted to by by way of newspaper publication, and pursuant thereof, a compliance affidavit has been filed. Right?
Yes.
Compliance affidavit has been filed. What's that matter, no? Now you are published in
Yes.
Akhomia Khobor,
On Akhomia Khobor,
Notice Times. No, no,
Yes,
Assamese you have already published.
Dainik Assam, Your Honor,
Then
and Assamia Khobor.
Akhomia Khobor. No, no, there was you could not publish in Assam Tribune. Is that case? No, it's not that case.
I have annexed, Your Honor, page number 37 and 30.
2 local dailies.
Yes, sir. Yes, sir.
As per order dated 15/10/2025, the petitioner was directed to publish the notice in two Assamese local newspapers. And pursuant thereof, publication was done and affidavit has been filed. As per the affidavit, para 2, within bracket para 2, it is stated that the publications were done in Doinik Ahom and Ahomia Khobor on 11/11/2025. Copy of the publications has also been annexed. It's better to annex the little larger part of the newspaper. Anyway, this will do. Okay. But this is all for, it's better for your, it strengthens your affidavit. More than one month has elapsed from the publication, newspaper publication on 11/11/2025. None has appeared on behalf of the respondent. Respond number 2. Therefore, the case can be proceeded with, perhaps. On the next date, we'll take it up.
Yes.
It was at the stage of, it was admitted or it was at the stage of admission only?
The admission.
Let me check it. Hey, you're handling? You're handling.
Formal,
Assess.
formal part.
It's a police case.
Police case. Protocol.
Interim order granted by order dated so and so stands extended till the next date of listing by 28 June 2025 stands extended till the next date of listing. List the matter again so and so. It could not ascertain. It is at the, it has been admitted or not admitted? Okay, list, not sure, I could not make out. List in the admission column on, you can suggest a date after vacation, after vacation.
Conveniently date may be fixed.
28/1. 28/1. Rest you have to take dates, I think. The other matters you have to take dates. Hearing, of course, none of them has reached. Just similar matters. 48, 49, 50. Hearing, he will give you the dates. Hearing, he will give you the dates. Orders, do not touch. Order 45, 46. And 56.
45, your lordship, was actually for the report on the basis of the notice issued to the in POXO matter, your lordship.
POXO matter.
And then on the last occasion also they did not appear because notice was not served.
This was for, this is this for execution, suspension of sentence?
Yes.
Suspension.
No, this is for delay condon. There's a delay
So
condon.
it's a delay condemnation.
And then your lordship, in that case, amicus can be pointed to you. That's
The service, could you take instruction in the service?
on the last occasion, they have taken the instruction on that. It was not
90%.
complete.
45.
45.
service is complete, no problem, we can take it, so that matter can proceed. But service has to be done.
On the last occasion, learned friend was asked to take the instruction whether.
Oh, I see, yes, instruction. Otherwise, we'll fix another date, he is not. Hmm. Take the instruction, whether it has been served. Instruction not yet. Instruction not yet received. The prosecution shall take the instruction regarding service of notice upon the informant, right? Informant R2, respond number 2, so that the instant proceeding can go ahead. We'll stop. List the matter on, you can suggest.
Let be on 9th.
9-1. Then.
My lord, item number 47 is a hearing matter.
Hmm.
My lord, was pleased to fix the matter, so, because on the maintenance case, my lord, some urgency.
Maintenances,
Maintenance.
19.
My lord, I pray, my lord, on Thursday, because my lord, the petitioner before lordship is in some problem, because the police is running after him, my lord. Actually, the opposite party is not entitled to get the maintenance.
That will have to take, this
So,
week
my
it
lord,
will be
this
difficult.
matter, my lord, Thursday, my lord, as you lord.
This week will
two
be
times,
difficult.
my lord, it was left over. That is why, my lord, on Thursday.
Hearing matter this week, I doubt it will be possible.
My lord, because the case is fixed in the trial court, my lord, repeatedly, my lord.
Fix it.
Thursday, my lord.
8,
Yeah. My lord.
18, but I doubt many
My lord,
matters have been
if I
fixed.
may-
More than 45 matters
yes.
already. Okay, otherwise we will take a date after fixed.
Item 56, Lordship, 2 days, 4th day, Lordship, for left over. Condonation of delay, Lordship.
This sentence, no? 5-year sentence, 3 years.
Maintenance, Lordship.
No, I 46.
What
Yours is 56. Delay condonation.
Delay condonation,
Delay condonation in maintenance matter.
Lordship.
Why is it, we have appointed amicus also.
Yes, Lordship.
Amicus also.
Amicus have it already.
Take it up.
19, Lordship. Already, Lordship, the judicial custody is the 2 times, Lordship.
Because otherwise we'll have to take up. Okay, 19. I don't know whether it will be possible. For your satisfaction, 19. And then 46. 46. This was for 4 years of
5 years.
5 years.
conviction. They have been behind the bar for about 11 months, Lordship.
You have to hear actually.
Section
Get
50 violation.
take a
is-
date. No.
Can
when-
it be tomorrow? Can I take a
Tomorrow,
chance tomorrow? Lordship?
tomorrow again, it will be list has already come. Seems long list. Wait for a few more days after vacation.
Can it be 6?
I have a
Lordship?
plan actually. Next time I sit on the roster for next year, next time, whenever I sit on this roster in next year, new year, I'll have a dedicated slot, at least 4 to 4:30 for orders.
Lord.
Then we can touch at least some matters we can touch if they don't reach earlier. Whenever I am on this roster, next time. Anyway, so this time public prosecutor you can suggest. It's 5 years conviction. He's seeking after vacation. Let it be immediately after vacation. We'll take it. 5 on 5th.
Can it be 6, Lordship? It's a
6.
hearing day.
Yes, 6.
Much obliged.
Fixed.
Lordship, I am for 57, your lordship. It had also come up on.
We had mentioned just now, 50, which is 57. Oh, there's another one.
Yes, your
Huh.
lordship.
Not seen also this one.
Lordship, essentially the short story is that the petitioner had filed a case against the respondent number 2 under 376 IPC. Thereafter, the honorable court stayed the case and he was granted bail. Then subsequently, he barraged the petitioner with a number of false complaint cases, many of which were dismissed, and against which some of which they have filed a protest, and again those were also dismissed, your lordship. Currently, we are here for CR case number 616, which is pending before JMFC first class in Kamrup Metro, your lordship. We are here regarding that.
Okay.
So, your lordship, it
Give
would
me
be a
the
great
file.
injustice if the
Give me the file.
original 376 case was to be stayed, but then such complaint cases of extortion and
57.
fabrication of evidences are still maintained against the petitioner, your lordship. So at this stage, we were only asking for a stay on the matter, and then we can hear it at length when the petitioners are also present, Your Lordship, because the petitioner.
You're for the respondent.
No, I am for the petitioner.
Yes, yes, that's what I understood.
The respondents.
Possibility
not
of
here.
time. They have appeared. Have they appeared?
Not to my knowledge, Your Lordship.
Service?
Service report was, it was supposed to be done by WhatsApp, Your Lordship. We have done it. And we have sent the notice by WhatsApp, but we have not received any intimation as such, Your Lordship. So in that
You can
case,
submit that maybe screenshot, colored screenshot. It can have the blue tick
Lordship.
that will indicate that
Lordship.
it has been read.
Lordship.
That you can do maybe.
Then
And so-
we may fix it on Thursday or Friday, Your Lordship.
No, not this week. It will be very difficult. I can fix it, but no purpose will be served because bail matters expected. More bail matters are expected, right?
Maybe for
Prime
the-
officer.
Yes, Your Lordship.
Because they
Maybe
have
for
to
the
appear, you know.
Recognizance of the notice, Your Lordship. Otherwise, nothing.
This
much
is
done.
the complaint. This is the complaint. Which you you are challenging. Which is the complaint page?
Just a second. It's complaint case 616 of 2024. It's paid.
This one, I think. 616.
Yes, Your Lordship.
Hmm?
Yes, Your Lordship.
Complainant versus so and so. Uttar Pradesh. Job right there. Or here also you can go for. She's staying in Arunachal Pradesh.
Yes, sir. Yes, Your Lordship.
No, normal post for raised by registered post, it did not come back. No.
Nothing, Your Lordship.
Did you
because-
take steps by registered post?
Yes, Your Lordship, because there is another case in which they have gotten stay in the 376 IPC case, Your Lordship.
No, just a minute. It is order 5325. Shall
Yes, sir.
take steps by our registered post as well as usual mode.
Yes, Your Lordship.
What is urgent land council petition? Petitioner is the matter after petition. Registered post. Then the notice came back unserved.
Yes, Your Lordship.
Newspaper publication was also directed. You were given the liberty.
Yes, Your Lordship. We have done it on WhatsApp, Your Lordship. I will collect the report on that.
No, but I think the obvious thing you have to clear because otherwise, see, they have so many disputes between themselves, right?
Yes, Your
You
Lordship.
know, you would agree. They have so much disputes between themselves. So otherwise, this will be a bone of contention. But I was never served.
Sir, that is true.
So
Your
we
Lordship.
better clear that so that we can, go through it. I would suggest that you can take fresh steps once again. Take fresh steps. Registered ID electronically as well as newspaper publication. I cannot because it involves some cost. If you're willing, it's okay.
Yes, Your Lordship.
Otherwise, if it is difficult,
The difficulty, again, Your Lordship, since it's a different state, it's very difficult. to
local
ascertain as
newspaper
well.
won't do.
Yes.
Local news. You're Mr. Bhattacharya?
A Mishra, Your Lordship.
A?
A Mishra.
A Mishra, Learned Counsel for the petitioner side, who's seeking quashing of CR case number 616 of 24 before Learned JMFC Kamrupem. Stuff. upon perusing the this record, the petitioner side is directed to take fresh steps by speed post. You take it by speed post, as well as electronic service.
We'll do both.
Upon the respondent, upon the respondent number 2. Thereafter, we'll see. Respondent number 1, sorry. Respondent number 1 / private respondent. Thereafter, we'll see. This does, then it's okay.
Then your
Telephone-
lordship can go for, we can go for first week of January itself and well, after we.
Well, no, if you go by this, it'll take some time. It will be better to fix it after that, thereafter. Today is this.
Then 20th, your lordship, 20th or 21st.
Yes, we can fix it on around that time. 21/1. 21/1.
Highly obliged.
All right.